Okay, well, welcome everyone. Thank you all for attending our Zoom first look or initial look at some preliminary proposals on police reform. I want to say just at the top of the hour, we have a couple members that are still waiting to get in. They're having some technical difficulties. So Senator Lee, Senator Reedy, and Senator Castley, they will be on shortly. So I'll open up by saying this. We're obviously at a historic moment in time, and that's been highlighted by the death of George Floyd and also countless others here in Maryland and throughout the nation. And it's incumbent upon us as legislators to seize upon this moment to enact some long overdue systemic reforms. Now, it's important to understand that this is not an affront to law enforcement officers. And I think I speak for the entire committee when I say that we hold them in the highest regard and have the highest level of respect for the women and men that serve us in uniform. This is about implementing systemic change, long overdue reforms that will help restore trust between law enforcement and the communities that they serve. It's also important to realize that the process of implementing real wholesale systemic change will invariably engender opposition from a multitude of different sources. Some will say, why are we focusing on this when we have yet another year of record murders and shootings in Baltimore City? Others will say we simply haven't gone far enough and that we need to keep pressing on for more reform. So I just want to say this about transparency and the process. As I said in my June 4th letter, you've got to start somewhere. And that's exactly what this is. These are the ideas before you are just a starting point. Today is just the beginning. Ideas will be added, some will be replaced, some will be removed. And what I've done here is to provide a forum to hear concrete ideas, not just concepts, so that we have ample opportunity to refine and work on these pieces of legislation before our session begins in January. Now, the bill sponsors will now have more than ample opportunity to discuss the issues with activists, interest groups, legislators, and most importantly, the communities that they serve. You've got to remember that we are still very much in the midst of a pandemic. We don't know what session will look like or how long it will last. And in the midst of such uncertainty, I've moved to ensure that we are in the best possible position to take action as soon as we get back. So I'll say it again. This is just the starting point, and we have so much more work to do. And I'll say respectfully that when we are done with this process, this will be the most transparent and the most inclusive process we could have had under these circumstances. So I look forward to working with all of you to ensure that we get this right. And I'll just conclude by saying that I want to thank all the members of the committee for making time today and for the next 3 days, and to all those that have taken an active role in this process. Finally, a huge thanks to DLS and the staffers and the attorneys there. They've put countless hours into making sure that this happens and to facilitate our work here today. And I can't thank you enough. Real public servants and allowing us to do some critical work at this critical moment in time. So now I want to give the members of the committee an opportunity to make opening statements. And I see, I'm going to look around the room visually here. And if someone wants to raise their hand, we'll go with them first. I see Senator Carter. So Senator Carter, if you'd like to make your remarks, go ahead.
Thank you, Mr. Chair. I want to thank you, Chairman Smith and Senate President Bill Ferguson, all of our committee staff and DLS staff as well that's worked so diligently on putting together a package of bills that we could hear now. It's critically important, and it was done under difficult circumstances due to the pandemic in particular, and the fact that normally we are not this busy drafting legislation during this time of year. I think that just as we seek to produce measures that will hold law enforcement more accountable to the people that they serve, this is about us being accountable to the people that we serve. This is about us taking our position as legislators and lawmakers seriously and coming up with responsible legislation that puts the people that we serve first. There should not be a disparity between people and law enforcement in terms of one group being on a pedestal and another not. And so what I am feeling today, and I think it's important to convey, is that between 2013 and 2020, I sponsored more than 30 pieces of legislation designed at police reform. And according to the ACLU, from 2013 to 2019, during that very time, there have been no less than 138 documented killings of our citizens and residents by police. It is my belief that we have been too slow, that we have taken far too long to take this issue seriously. It is because of our fondness, affection, reverence, and respect for law enforcement that for far too long, we have ignored citizen complaints. We have ignored the millions of dollars that we spend every year on settling actions, civil actions against police for brutality and excessive force and wrongful death. And now is the time that we must take it seriously. There should not be a two-tiered system of one system of due process for people and public employees and another specifically for law enforcement. I feel very strongly that that is the message we've got to send to our constituency. And I want to say that a number of the pieces of legislation that we're hearing now are pieces that have been introduced out of the more than 30 bills that I introduced over the last years from 2013 to 2019. Only 2 of those bills passed. That was Christopher's Law, which reassessed training in certain areas, and a data reporting bill. But in terms of the Law Enforcement Officer Bill of Rights, whistleblower protections, duty to intervene, changing liability caps, requiring drug and alcohol testing, considering liability insurance, considering decertification of officers, none of those bills have ever been considered by this body. And I am hoping that we will consider it, we will do it responsibly, and that we will take votes of our conscience, and no longer will we choose to take the easy way out and not adequately debating and addressing this issue. So thank you for your time. I'm looking forward to hearing the testimony of everyone that's involved. Thank you.
Thank you, Senator Carter, and thank you for your work. And obviously, you're going to have an opportunity to have your say, and I think we're going to make some progress. So, Senator Huff is next in the queue.
All right, thank you very much. Can you hear me?
Roger that, we can hear you.
All right, perfect. Just want to say a couple things. One, I'm glad to hear you say the process is going to be transparent and inclusive. We're going to hear today. None of them are coming from the minority party. In fact, Republicans were not asked to submit any bills or ideas on this. So I find that a problem to begin with. And to say that we have not brought up police reform, or that it's long overdue, I actually think is a untrue statement as well. You'll remember after the Freddie Gray's death and the riots in the city of Baltimore, we actually had a process that was put together. We had a task force, both the House and the Senate did it. And in that time, we came together. We listened to problems. Members of our committee, members of the General Assembly went out, we toured the state, we listened to activists from the community. We went to the Maryland Police Training Commission. Many of us, like myself, took part in the training, saw what the officers went through. It was a months-long process to hear what the problems were and how we could address them. At the end of the day, we ended up passing a bill through the Senate 46-1. And I would say that that process was much better in that we started off trying to figure out what the problem was and looking at our laws. Instead, with this hearing, we began talking about an incident in Minnesota, which, with all due respect, I don't control Minneapolis law. I don't control Minnesota's. We are in charge of Maryland's law. We just did a police reform passed by a large bipartisan margin. And now this session, we're coming into a process that is beginning on a very partisan tone in that we have 15 bills. Republicans weren't asked to offer any. And I find that very troubling. And I'll just say in response to some of the other data that's been given out, when you talk about police shootings, There's 10 this year. There's been on average, if you take the city of Baltimore, there's been on average 2 a year. Yet we're having hearings on this, but yet we're not addressing the crime in the city of Baltimore. There's 1,000 shootings, civilian on civilian, every single year. So we're not taking time out to talk about that issue, even though we just had 50 shootings recently in the city. We're talking about this issue, policing, because this fits into what is the national agenda right now. And so, look, I'm open to finding solutions and working to improve our laws, and I'll work together like I have in the past on issues like justice reinvestment and policing reform. But I'll speak for myself and the other members of the minority party on here. We can only work together if people want to. If it's a decision by the majority to defund and demoralize the police agenda, then we're going to resist that. But if there's an honest effort to improve Maryland's laws, then we'll be a part of that. But up to this point, the actions that have been taking place, I find very troubling, disconcerting, and go against the spirit of the Senate. But the Senate has a long tradition, especially on criminal justice issues, whether it be the historic Justice Reinvestment Act, policing reform, civil asset forfeiture, time and time these contentious issues. And we've passed them almost deeply troubling, and it makes that much more difficult.
Thank you, Senator Huff, and I assure you that we look forward to working in earnest with everyone in the Senate, and so I appreciate that sentiment. So moving along, and thank you for being here. So I know you're running to work. Senator Sidnor is next. Then we'll go to Chris West, Senator West.
All right. Thank you, and good afternoon, Mr. Chair, committee, and members of the public. I would first like to thank this committee for providing a platform for these hearings. When I was first sworn into the General Assembly as a member back in 2015, this nation was struggling with similar events to which we're struggling again today and now facing. The world saw and responded to the death of Mr. George Floyd, and it has encouraged me that it seems that people are beginning to empathize and understand. Obviously, that was not in the state of Maryland, but obviously some will characterize our efforts to ensure justice for everyone that our efforts are anti-police. I assure you, they are not. My family includes retired Baltimore City homicide detective, an FBI agent, correctional officers, as well as parole and probation agents. My efforts to ensure there is accountability should not be mischaracterized because I advocate for the change of a system that has proven plenty of times to be unjust. The Maryland Police Accountability Act, of which my bills are a part, is a part of that change that is being called for by vast majority of well-meaning people across the state of Maryland, as well as in my district. This is our response to their plans to reset the law so that law enforcement is held more accountable to the public that it serves. And it is only the beginning. Public safety is not just about locking people up. I suggest that we not forget that police are not the complete system, but just a part. I plan to have legislation which will also look to how our prosecutors carry out their duties. And I'll also look to our courts. So with that, again, I do thank you. I have 2 bills that I'll be presenting today that are, again, just the beginning, and I look forward to working with people in the community during the rest of this interim. Thank you very much.
Thank you, Senator Sidnor, and obviously, I mentioned this before, but you've been a champion for these issues since your time in the House. So thank you for your continued work. We'll now move on to Senator West.
Thank you, Mr. Chairman. And I want to first thank the staff of the committee for putting these hearings together at a time of the year when the staff normally isn't working like this. We're 3.5 months before the convening of the General Assembly, 2021 General Assembly. So this is a time of the year when people just aren't expecting to attend hearings or to put hearings together. So congratulations to the staff for pulling out the stops on this. My background in this is I was a member of the Justice Reinvestment Work Group a couple of years ago. And it seems to me that should be the model for approaching comprehensive legislation to change a whole area of the law. We all got together on a bipartisan basis. I was in the House at the time, and we had our bipartisan work group, and I know the Senate had its own bipartisan work group. We worked through all the issues. We ended up getting a draft of a bill, and literally we went through that bill line by line as a committee, pulling it apart and putting it back together again. I was also in the conference committee, and we spent until 9:30 at night on the Saturday night before Sonny died, again, discussing the issues with each other and making reasonable compromises in order to bring bills to the floors of both houses, which ended up passing almost unanimously in each house. It was a genuine consensus bipartisan effort. It seems to me that's the kind of effort we should be engaged in this summer, this fall, and then next winter when we convene as a General Assembly. Instead, today we have, and tomorrow and Thursday, we have 15 bills, all of which to a greater or lesser extent are anti-police. And that is evidenced by the fact that the police and the prosecutors have filed opposition testimony to virtually all of these bills. I know I have some bills of my own in this area that I would like to be considered, but I was not asked to get my bills prepared for consideration at this time. Only 3 members of this committee were asked to present bills. They're all members of the majority party, and as I indicated, the bills are all to a greater or lesser extent anti-police. I just think it's unfortunate that we're starting off on this way rather than trying to reach a consensus in a bipartisan way, as we did on the Justice Reinvestment Act. 2 more points, and that is I went through the testimony. The testimony is really thin. I think a grand total of 10 people have submitted testimony on these pieces of legislation. If these bills had been introduced during the regular session, we would have had piles of written testimony from various people, advocates, public citizens, etc. The fact that only 10 people have submitted testimony suggests that because these bill hearings are being held in September, when no one expects bill hearings to be held, virtually nobody knows about these hearings. And a lot of people who would like to be heard are not going to have an opportunity to be heard because the bill hearings are not occurring during the regular time that we hear bills during the legislative session. Finally, let me just say, I'm a Baltimore County state senator, and more than anything else, I'm concerned about the policing in my county. I'm certainly not going to do anything which is going to cause the morale of police officers in my county to go down. I note parenthetically that last year there were 750,000 encounters in Baltimore County between policemen and citizens. 750,000 encounters. Also last year, there were a grand total of 50 complaints filed against police, and more than half of those were filed by police officers against other police officers. So we're talking about fewer than 25 complaints filed by the citizens of Baltimore County against their police officers. My impression from 6 years of going to community association meetings and listening to police officers talk is that the people in Baltimore County like the policing they're getting in Baltimore County. So I think we need to be very careful about passing legislation which is going to greatly demoralize the police across the state and in Baltimore County in particular. Thank you.
Thank you, Senator West, and your concerns are heard and received. I'll just say one thing on the process. This is, again, just the beginning. And so this is obviously an iterative process. We have 3 months to refine legislation and to go out into our communities. The bill sponsors are going to be responsible for going out, touching activists, interest groups, members of their community to get input and feedback and have a refined piece of legislation for us to consider and work on in session. But by doing this now, we have an opportunity to have we're ahead of the game, especially with the uncertainty and there's so many variables with what session is going to look like in the midst of a pandemic. This is an issue of such great importance that we have to start now. And that's what this forum is about. So it's just the beginning of the conversation. And that's why we're all here today. So I appreciate that and message received. We're next going to move over to the Vice Chair, Senator Wallstreicher, and then followed by Senator Reedy.
Thank you, Mr. Chairman, and thank you for your leadership on these critical issues. Like me and each of us on this committee, you wear multiple hats. You're a dedicated father, you're a devoted husband, you're a zealous advocate as a practicing attorney. And yet, despite those heavy responsibilities, I know firsthand that there has not been a day that's gone by since June, not a day that you haven't thought about advancing the cause of racial justice. History calls upon each of us to meet this moment. Today is definitive proof that you, President Ferguson, and Senate leadership are meeting that moment head on. During this era of partisan politics and finger pointing, the Judicial Proceedings Committee is here this week to solve problems, including those related to policing and law enforcement. These issues are emotional, even painful. Effective legislating under these circumstances requires each of us to be thoughtful and purposeful. I'm thankful for this opportunity to join together today to have constructive and meaningful discussions about these challenging issues. In the weeks that followed the murder of George Floyd, tens of thousands of Marylanders protested peacefully in my legislative district and throughout the state, and they were demanding that we work to fix systemic injustice. Marylanders of all stripes are looking to us today to ensure that they are safe in their communities and free from abuse and inequity. We cannot and should not turn a blind eye to the calls for accountability, transparency, and reform. Today is the day that we begin the healing process between law enforcement and the communities they serve, including communities of color. We must restore public trust in our policing organizations, which of course is what these hearings are all about. The bills in front of us give us the time and the space necessary to address injustice while recognizing the danger and complexity of the police profession. They're a starting point for us to receive meaningful input from constituents and stakeholders. Issues of police reform require thoughtful and nuanced solutions. Getting this right means we need enough time for advocates on both sides to work through the implications and meaning of each and every word in these specific proposals, not merely just talk about concepts. I know Ruth Bader Ginsburg was a hero to many of us, and she was the first and only Jewish woman to ever serve on our highest court. And she famously said, "Fight for the things that you care about, but do it in a way that will lead others to join you." Mr. Chairman, I know that this is something you and President Ferguson care deeply about, and I'm proud to join hands with each of you this week. But perhaps more importantly, I'm proud to join with the advocates and organizations in this hearing for the most important fight of our lives, the fight for racial justice. Thank you, Mr. Chairman.
Thank you, Vice Chair Walsh-Aker. I couldn't have said it better myself, and I know that we're both from Montgomery County, and we both were, part of and experienced those peaceful protests and those calls for racial justice. And so, just want to say thank you for your work and your support, and I look forward to working with you as we move forward. So, we're lucky to have you in the Senate, and the residents of District 18 are lucky to have you as their senator. Senator Reedy.
Thank you, Mr. Chairman. And we've heard from several people sort of the unprecedented nature of us sitting here having what's being characterized as bill hearings. It's difficult to understand legislatively. We can't really be having a real bill hearing if a bill has not been officially introduced and read across the desk. But I don't want to get bogged down too much in process debates. We've talked about how number of us were really not invited to present bills that could help with some of the issues that are really pressing. It's my view, and I think it's the view of the Republican members of JPR, that a far greater issue as it relates to police and community relations and racial justice is the violence that's taking place in Baltimore, the murders and the violent crime that's being committed, not just in the city, but in the Baltimore region. And so if we were going to have emergency hearings, I think that would be a place we would want to start as part of the conversation. But I just want to say this as we enter this process. No one that I know and that I've spoken with, including people who are very involved in law enforcement, no one that I know is against improving police processes, improving policing. No one is against helping communities and police interact better and in a more effective way together. And nobody is against making sure that wrongdoing that's been proven is addressed firmly, fairly, with justice. At least when that wrongdoing is by police. We have sometimes seen that there are excuses made for wrongdoing when it comes out of maybe the community. And there's a desire to say that doesn't really count because of systemic issues. And I've seen that time and again. That's what's frustrating about this for me as someone who is not, I'm not somebody who believes we just want to retreat to our corners and say, no, the other side's all wrong. But the rhetoric that surrounds this debate has really created a toxicity among the men and women of law enforcement who are really doing their best every day. And I hear from them so many times. I have family members who are in law enforcement, but I hear from, Carroll County that I represent, a lot of police officers live in Carroll County and work here, or perhaps work in the city, or work in Baltimore County or in other towns. And they're people who they don't want bad police officers or poorly trained officers out there doing things that are wrong, but they feel completely under attack because of the national environment and the rhetoric that we see. And I just want to say the credibility, all of us were stunned and were saddened by what happened in the case of George Floyd. Senator Huff pointed out accurately that did happen in Minneapolis, Minnesota, where they do not have some of the extensive protections in law that we have passed here in Maryland. But the credibility of legitimate movements for positive change, the credibility is harmed when there are protests, violent protests many times, before all the facts have even come in on a police interaction or shooting. 2 weeks ago in Lancaster, Pennsylvania, there was an officer shot a man, and within 24 hours, there was protest right away, but within 24 hours, body camera footage made it very clear that the individual was not just wielding a knife, but was assaulting the officer and had been threatening an ex-girlfriend and had a criminal record that involved stabbings. But yet for about 48 hours, there were riots and protests, even after the body camera footage came out. And that's just one example. But we must ask ourselves, I think, as we consider any of these bills that we're talking about, and we'll be considering them, I think, for votes when we get into session. But the question we should always ask about legislation in any area as it relates to police reform and these kind of policies is, are we setting up an impossible standard for use of force where any use of force is presumed guilty or is presumed to be too much and the officer has to desperately prove their case? Of course, any use of force should be examined closely, and it is in Maryland. But are we setting up an impossible standard where officers will be afraid to intervene? Another question, what is it about Maryland's police training standards, which already emphasize de-escalation and the use of force as a last resort? What is it about those standards that are not enough or not working? Why is the reform law we passed in 2016 not enough in some of these areas? What was missing or what needs to be tweaked? As opposed to standing and saying it all needs to be junked or the whole system is corrupt. And I hope none of our members are saying that in their bills, but we certainly hear that from activists. And I think the last question would be, what have the groups that we will hear from today and the next couple of days, what have they done to create greater cooperation in communities with police by dispelling wild accusations and conspiracies? With hundreds of murders and rising violence in Baltimore and the surrounding area, what role should police have in the minds of those who say we need to take greater action, have greater restrictions, and greater limit police? What role should the police have? And I think those are honest and fair questions. And so as we consider all of these issues, I think it's really important, and in closing, I'll say it's really important that we have not just a one-sided barrage of bills like we frankly have in these hearings, or a one-sided attack on police, nor should we have obviously we shouldn't have it the other way either. We need a two-way conversation. It really means in this country, we need a two-way conversation between communities that feel frustrated and the police that also feel frustrated, that are trying to do their best. We need a two-way conversation where we really try to resolve. Sometimes I think it could be misconceptions. Sometimes there are issues that need to be looked at. That's what we need. I'm not sure that that's what we're going to have here. I'm concerned, but I will participate as I always do, trying to. I come from one perspective, from a strong perspective, a pro-law enforcement perspective, but I think we want to hear all sides of the debate. But let's really keep in mind it needs to be a two-way conversation, not just an accusatory tone towards law enforcement. Thank you, Mr. Chairman.
Thank you, Senator Reedy. And just again to reiterate, we've had, obviously last year we dealt with, we passed a bipartisan package of addressing violent crime and then also making record investments into community and violence prevention programs in Baltimore City. So I know we've worked in a bipartisan way before, and we'll do so again. And so thank you for your remarks. I know that Senator Castley, did you want to jump in or?
Sure, please. It took me a while to get on, but I appreciate the help from the president's office and the committee staff to get me through. Good to see you all. So we received a letter yesterday from President Ferguson in response to a letter from the Republican caucus, and the president said that these extraordinary proceedings that we're involved in here are necessitated by what he described as systemic injustices that exist in policing, which he said he believes, quote, prevent citizens from feeling safe in their communities. And I have to seriously question the Senate President's perception that injustices in policing are preventing citizens from feeling safe in their communities. And I say that because as we are undertaking this hearing, on police accountability, the citizens of Baltimore are suffering from unprecedented levels of shootings and murders. And a recent 10-day period saw 50 non-police involved shootings. And every year the murder rate reaches a new historic high, with most of these being civilian on civilian shootings, and the majority remain unsolved, leaving the killers free to strike again, roaming the streets. And at the same time, police involved shootings in Baltimore City average about one a month, 3 to 4 fatals a year. And in Baltimore County, 4 to 5 police shootings a year, for a county that's, I guess we're about 900,000, close to 1 million in Baltimore County this year now. And each of those police involved shootings is subject to an intense investigation by federal, state, local investigators, subject to administrative investigations, civil lawsuits, and the attorneys investigating those, private investigators. And so as a result, these officers are subject to indictment, termination, demotion, and financial liability. So since we're about 189 years old now, our committee. And for the roughly last 189 years, we've been responsible for approving Maryland's laws on crime, juvenile delinquency, policing, police safety, public safety, courts, and more. So, of course, it's really important for us that we take seriously, after 189 years of our efforts, that we're witnessing what can only be described as a crisis in the rule of law in major parts of our state, as these non-police involved shootings and murders are destroying the lives and causing the citizens and businesses to flee our urban centers. So under the circumstances, I think it's really critical that we use this committee's resources very wisely and without reservation to understand and honestly address the rule of law challenges that have the greatest impact on the lives of the people across the state. I encourage us not to give in to demands of special interest groups that in many cases are determined to redirect the efforts of this committee towards their personal political goals. People of Baltimore, I see, are suffering already the devastating impact of a violent crime wave that in many regards was unleashed by short-sighted politicians who, to satisfy their really selfish political ambitions, have politicized, demoralized, and devastated the entire police department of a major American city. We have to understand and offer real solutions to those young people raised on the streets without fathers, abandoned by a union-dominated school system, and left unemployed by misguided policies that drive quality employers from their cities. So the police are not the problem here, because really they, like the citizens, are just victims of the failure of governance. And there's a catchphrase I saw on Twitter the last day and a half, says that we cannot use policing as a substitute for curing underlying social problems. But I challenge you to find a single police officer who believes that arresting and jailing people cures an underlying social problem. It's not the police job to cure underlying social problems. Rather, it's their job to isolate, prevent antisocial behavior from destroying countless other innocent lives. So just to be clear here, we're not in the midst of a crisis caused by policing. Rather, what we're seeing is the devastating fallout of seriously broken local governments shaped by decades of single party dominance that covets power over competence, control over integrity, and politics over lives. And I've reviewed these 15 proposals, most of our ideas rejected by this committee in a bipartisan fashion over the last several years, because we felt they undermined the very difficult and critically important job that our law enforcement officers perform day in and day out, trying to deal with the immense public safety challenges that are thrust upon them. And unfortunately, I have a trial tomorrow, so I can't give my full attention to these matters all of today and probably none of tomorrow. Obviously, during the session, as an attorney, I have a right to raise under the law. I can say I have a trial, and the judges. I'm a legislator, and you shut that down, and I go on, and they have to postpone the trial. I can't do that right now because we're not in session. But I'm going to try to monitor these proceedings over the next couple of days, just to the best that I can. But if you see me ducking out, it's not because I'm not interested. But in closing, I previously set out to this committee in detail and in writing my careful thoughts on 3 areas that I believe we can make a significant impact to improve the rule of law in Maryland. And those are the failure of the juvenile justice system, the ravages of the revolving door on criminal justice system that returns violent offenders to our streets to kill and maim again, and the challenges and most recently, the challenges caused by the union exception to the Law Enforcement Officers Bill of Rights. And I welcome discussions from any of my colleagues on these topics and see if we can't move forward with some bipartisan legislation on those areas. So, Mr. Chairman, thank you. I appreciate the committee members. I appreciate you giving me the time.
No, thank you, Senator Castley, and I appreciate you balancing the work of the citizen legislature with your law practice and your responsibilities here. Now, for the members of the public, look, you've seen a balanced discussion here, and you've seen both sides of the issue. Obviously, we are in unprecedented times. This is an unprecedented forum for these issues. And so as we move forward, just keep that in mind that, you've got folks from all across the state, all 24 jurisdictions that are coming together to try to solve these problems. I'll just end with this, to say that the public safety issues that we face are inextricably linked to the transparency and accountability. They go hand in hand. And so if we could keep that top of mind as we move forward, I think that would be instructive. Senator Lee has now appeared. Good, we're good to go. Senator Lee, I wanted to offer you an opportunity, and then Senator Young, if you wanted to make some brief remarks. If not, we'll move on to the hearings, or to the.
Very glad to be on these hearings now. I think some technical difficulties getting online to the meeting, but these are very important meetings, important hearings, and I'm glad to be able to participate today. And I think what we will preside over is very important for the future of Maryland. Thank you.
Thank you, Senator Lee, and Senator Young.
Yeah, I'd like to make a few remarks. An awful lot of what I would have said has been covered, so I'm not going to try to repeat much. But I do think we get trapped in by national matters in a way, and I think we're very bad with slogans. Black Lives Matter. I wish they'd put 2 on the end of that. We all know what it means. A lot of Blacks have not been treated equally in the system, and they should be. But the way it's worded, other people look at it and think they're excluded. So if it had just said Black Lives Matter also, or 2, that would have helped. Same thing with defunding police. I hope none of us, I don't think we do, want to stop funding the police departments. Again, I think the meaning of that was that there are a lot of things that we make police handle that ought to be handled by somebody else. I've, over my years as mayor and whatever, ridden with the police, and you see some things, their jobs are not easy. And I want to make a real clear point here. The majority of the policemen I've known are good people trying to do a good job, but I've seen some bad eggs, and they need to be eliminated. But if you've ever walked in a situation where a policeman's had 2 and a husband and wife are fighting each other, and the policeman tries to break it up and they both turn on him, it's an uncomfortable position to be in. And then quite often the couple want to testify against the police officer. A few things that have been said that, again, I want to touch on. everybody wasn't excluded. I called in when I first saw this list and said I had a bill I'd like to send down, and staff person told me we'll deal with yours later. I personally think mine does more than any of the ones submitted. And I'm not going to get into it today, but it's touched on among the other things here, but I don't think nearly as strong as it should be. But I do think there are a lot of good ideas in these bills. We ought to discuss them. We ought to get the viewpoints from the other side, and where it's appropriate, take some action. And I think if we eliminate the Bill of Rights, which frankly I don't have a problem with, a lot of the other things pick up a lot of what's in the Bill of Rights and offers protection both ways. And so I think we can get rid of something that I think was good intentions and hasn't worked out so well in a lot of cases, and cover issues that protect both the police and the community on both sides. And I hope we can do that. I would like to, I pointed out, I don't think we have major problems up here. I think there are some systemic problems that need to be dealt with. But I mean, we have 2 murders a year. That's too many. But when you put it in proportion to what's happening in some other jurisdictions, we need to really look at those jurisdictions. And I think Senator Casserly touched it. I mean, we need to look at the school system. We need to look at jobs, but we need to look at the police department too. And we have to take some actions to stop what's going on there. I think it gives Maryland a bad name all over. I happen to personally love Baltimore City. I think it's a great city, but I think it's got some real problems in this area. And I would also say we really need to take a strong look at how we help there, and working with them, not telling them what to do, but there are a lot of good ideas in other jurisdictions that worked. It ought to be a two-way street, and helping them, and also giving them best practices of what they might do differently to help their situation. But I think at this time, I think these hearings are a good idea. I think we're going to probably have to repeat them when we get back there. But maybe in the meantime, we can have some work done and have input, and where need be, take bills that are pretty good and make them better. So I'll stop there and thank you.
Thank you, Senator Young. Now we're gonna move into the substance of the day. So the way this is gonna work is that we have 3 senators presenting bills today: Senator Carter, Senator Sidnor, and then I'll bring up the rear. So Senator Carter will start off. She'll have 5 minutes to present her ideas, and then Senator Sidnor will go speak to his 2 bills, and then I'll wrap up, and then we'll move into the public, to the panels, okay, to the expert panels. So Senator Carter, if you'd like to kick off with JPR 1, which is the use of force standards.
Thank you, Mr. Chair. I certainly do wish I had an opportunity for rebuttal, but I will proceed.
You and me both, but it's okay.
So first, just Senator Reedy really touched on this, saying, you know, what is the problem? Asking what is the problem with our current standards of use of force? The first bill would endeavor to codify a statewide standard for use of force, putting as its priority protecting the sanctity of life, and then addressing when and how force is appropriately used, basically under a standard of necessity. And speaking with advocates, we believe, and I believe all of us believe that have talked about it, that this is a start, but that we need to work more on the language of the bill so that it accomplishes what we would like for it to accomplish. We are one of only 9 states that do not have a statewide statute defining use of force. As we go further and look at how we codify the standards for necessary force, and only when force is necessity being a standard, excessive never being acceptable, it's important that we encompass the need for adequate training for law enforcement officers, both in the beginning and in service training, to make sure that they are aware. Now, what this does is, one, it lets the public know what the standard is, and two, it also lets officers know and have clarity on what is expected of them, when it's appropriate to use force and when it isn't. And I think that what's very important is that where there is confusion, we have a lot of problems. There's been a lot of discussion lately about different ways to use force, like should we outlaw strangleholds, chokeholds or not? My position is that we need to have force as a last resort only when it's necessary, and it should never be excessive. The bottom line is that no matter what a citizen does, no matter what the condition of the citizen, they should not be killed by police unless it's absolutely necessary. Absolutely necessary. Because our criminal justice system is in place to basically have officers arrest, prosecutors charge, prosecutors prosecute and litigate, courts to determine outcomes. And none of those outcomes, no matter what the behavior of a citizen, is going to be the death penalty in Maryland. And so it certainly should never be implemented on the street by a law enforcement officer without any of that going on. And so I'm going to defer to a lot of the subject matter experts to talk more about what the statute should look like, what is done in other states. I want to thank David Roca of the ACLU, Ken Williams, a former homicide detective, Neil Franklin with Law Enforcement Action Partnership, Captain Sonia Pruitt, who is past president of the Coalition of Black Officers in Montgomery County and a former captain of the Montgomery County Police Force, Attorney J. Wendell Gordon, known as the Warrior Lawyer, and the Office of the Public Defender, who will all offer testimony on this and other bills. My 5 minutes is probably up and I probably talked too long on that. I have submitted written testimony, so I will defer to the subject matter experts. I want to just briefly say that in 2005, the General Assembly passed a law basically allowing for no-knock warrants. And what that has done is it has caused more opportunity for bad practices, more opportunity for officers to break into homes. This is well documented. And when officers break into homes, or the perception of the resident is that officers are breaking into home because there's no knock, they just enter the premises without warning. Citizens often believe, families often believe that they're being broken in, and so it puts them automatically on defensive. It also destroys a presumption of innocence because it denies people an opportunity to cooperate, to consent. All of that is taken away, and it further creates a problem between police and law enforcement. My position is that warrants should be knock and announce. That is adequate protocol. Our law already has exceptions for exigent circumstances in pursuit, when in active pursuit, that would obviate the need or take away the need to have a warrant under law. And I believe that's adequate. The other bill, duty to intervene, is very self-explanatory. We've seen many times, and Tawanda Jones is one of the many people that will testify in the public today about the way that the officers stood by when her brother was being killed, did nothing, and some participated in it. We need a statewide standard for the duty to intervene, with the duty to intervene and the duty to report. And in my opinion, it should be combined with the concept of whistleblower protection, meaning that when officers enter into a police force, into policing as a profession, they should be notified at the very beginning that standing by in silence is complicity. It will not be tolerated, that there is an absolute mandate that they intervene, that they report, and that they de-escalate any situation where possible, and that they will absolutely be protected. One of the biggest reasons why officers have been in silence, they've been afraid to speak up, afraid to report, afraid to intervene for fear of retaliation, which is also well documented. And so doing this, what we do is we create a safe, healthy, and protective environment for all of the good officers that I hear so much about and know personally that want to do the right things, but feel pressure and coercion in a culture of an agency where if they intervene or interfere or report, that they will be retaliated against by their fellow officers. And so this is all important. And I will just say that particularly on the whistleblower protection and duty to intervene, I hope you'll listen to Ken Williams, who testified with me on these bills all the way back in 2015, who has personal stories about being a whistleblower in his own agency. I'm happy to join with the subject matter experts in answering questions if I can. Thank you.
Thank you, Senator Carter, for your great explanation of whistleblower protections, the duty to report misconduct, duty to intervene, the use of force standards, and the no-knock warrant elimination. So thank you for that. Now we'll entertain questions from the committee to Senator Carter. If not, we will move on to Senator Sidnor, who will present the duty to report misconduct.
All right.
Yep. Misconduct.
I'm sorry.
Got it.
Yes, this afternoon I am here to present some testimony on JPR 2, which is deals with the misconduct database, as well as JPR 5, which will create a duty to report misconduct. As Senator Carter mentioned, I too will have some experts who will come later to talk and give more of an expert opinion on his. Debbie Levy from the Office of Public Defender, Professor Rashawn Ray from Brookings, and retired officer Neil Franklin. With regards to the misconduct database, while some of this may be a little new, for the most part, the concept is not. What this bill does is it orders the creation of a database compiling information directly from the state's attorney's office regarding officers with credibility concerns, as well as formal complaints that are made against officers at their place of employment. The bill calls for state's attorneys to keep lists that where officers have been found to or to have been alleged to have committed acts diminishing their credibility, integrity, honesty, and other characteristics that would constitute exculpatory or impeachment evidence in a criminal case. Again, this isn't a new concept. In fact, when doing my research, I came across an article from back in 2008 where Baltimore City State's Attorney at the time, Patricia Jessamy, there was an article about her use of such a list. However, her list was composed of those officers who engaged in conduct that is so egregious that it undermined the due administration of justice. And some officers, I believe, took exception to the broadness of that. I would say that this particular bill, or this set of acts, are a bit more narrow because, again, what we're trying to get to are officers that have credibility issues. They need to be called out. Additionally, as I mentioned, the bill would also create an additional list of based off of informational complaints filed with the police department. Now, in the past, when this has been done, research showed that generally you had officers who were against this because they felt that it unfairly tainted honest cops. What I'll say is this particular bill should not have that type of taint. And why is that? Because it includes any and everything. So if a complaint is determined to be unsustained or unfounded, the result will clearly be indicated for the public to see. So officers who have done no harm need not worry about being listed in the database with complaints providing this type of information. When one really thinks about it, I would say that it's akin to Maryland Judiciary's case search, where one can find publicly facing allegations. And obviously we don't believe that those publicly facing allegations are meant to shame anyone, and neither is this database. In addition, with JPR 5 in the duty to report misconduct, I'd like to point out that this General Assembly in the past have passed laws containing a number of statutory reporting obligations. Mandatory reporting obligations apply to certain professionals and have included duties to report information regarding infectious or contagious diseases, abuse of developmentally delayed individuals, abuse or neglect of vulnerable adults, as well as known threats of imminent physical injury and injuries apparently caused by auto accidents, lethal weapons, gunshots, and moving vessels. This particular duty to report misconduct outside of, except for the excessive use of force, the obligations that would be placed on the officers to report misconduct are all laws that would have been broken by the officer. So why is this necessary? I will say in focusing on our state, police departments throughout Maryland, I believe, at times have fostered office culture of officers protecting one another when they know that their colleagues have committed unlawful and inappropriate behavior. In its 2016 investigative report, the Department of Justice described how Baltimore City police personnel discouraged complaints from being filed within the department, as well as, and they conducted little to no investigation into complaints that were reported. That is not me saying this. This is our United States Department of Justice speaking about our police department here in Baltimore City. This culture must be eliminated, and public safety is at risk when officers who are supposed to be promoting public safety shield their peers who are guilty of dangerous conduct. And just to respond to how one deals with crime, it's all, as a pastor in Baltimore, PM Smith, and I always think about a quote that he mentions where he says, it's all about relationships, so it ain't about nothing. Crime does not get resolved if the general public does not feel that they have a relationship, a trustworthy relationship with Baltimore police. So we have to get our police departments back on track to make certain that the crime that is happening, that I'm ecstatic to hear that my colleagues from the minority party are concerned about in Baltimore City, because I'm concerned as well. No one wants any murders, whether it be committed by law enforcement or civilian on civilian. We don't want it. It's not acceptable. And I believe that the citizens around Baltimore City believe it's not acceptable. Unfortunately, for whatever reason, a lot of times our citizens don't come forth, and we don't provide the necessary resources to ensure that they come forth. So with that, I'll end my testimony and move on. Thank you.
Thank you, Senator Sidnor. Any questions from the committee for the senator? We have, I see one. Senator Castley has a question.
Yeah, thank you, Mr. Chairman. Senator Sidnor, thanks. I took taking these in the reverse order that you just gave them. This last one on the police duty. You know, would you have a problem with amending this bill? This is all one-sided on the police to report misconduct by police, but would there be a problem amending this to say that police would have a duty to report conduct by civilian authorities that direct them to, for example, stand down, to not take action against perpetrators of certain crime for whatever reasons they might do, so that when a police officer perceives some misjustice, some injustice on behalf of a superior, that it would be incumbent upon them to report that as well.
As the chairman said, that because these bills are just starting points, I'm open to discussing any types of amendments that this committee has. So I absolutely can discuss that.
And then for the, and I'm not sure this is intended, but in the bill dealing with creating the list and stuff, for example, see Court Judicial 9-125, this is on JPR 2, right? And we create this list of persons alleged to have committed acts which bear on credibility, integrity, or honesty. And under the provisions of that bill, these are all subject to inspection under the Public Records Act. So anyone who makes mere allegations against a police officer, regardless of whether or not there's any substantiating evidence, regardless of whether those allegations are just naked, that those would be public, and that any allegations against a police officer will become public. And the same thing for the complaints, that we're saying that a complaint doesn't need to be filed under oath. I can file a complaint on behalf of some person who I heard a rumor about, who heard it from another person, because it's not under oath, it doesn't require hearsay, and make horrible, malicious allegations against a police officer. And that would be open to the public review, regardless of the fact that there was no substantiating allegations or no substantiating evidence, and it was third party, not under oath. Is it the intent in both of these that these sort of just bills would allow for spurious allegations made against police officers should be made public, or is that sort of an oversight in the drafting?
No, I believe that by presenting and ensuring that all of that information that's related to those types of allegations would be included in the database, I believe that the public would be able to look at that and looking through the totality of circumstances, realize if a bull report was put forth, then we should be able to read those facts and understand that it was unsubstantiated and bull.
How do you explain to a police officer's kids that the allegations that some intoxicated person made when he pulled them over for a DUI, who came back and claimed that they sexually assaulted them and made horrible statements, that those kinds of really malicious kind of allegations, which maybe had no credibility at all beyond just the angered statements of a belligerent drunk who wanted retribution against a police officer for the third DUI they pulled over that night, that now that police officer has to live with that in their community, not just the police officer, but the spouse and the 3 kids and the parents and the grandparents and all this stuff have to live with the public record that some intoxicated person who was at a clear vendetta against a police officer is now going on the public record and slime this police officer's credibility irredeemably and without any hearing at all. Is that the intent?
No, what I think would happen in that case, and what I would hope would happen, is if someone filed a false report against law enforcement and claimed that someone had raped them when they didn't, that our prosecutor would step in and you have perjury charges. That's unacceptable.
But there's a difference between perjury and just, I mean, I can make any naked allegation I want. Perjury, to file perjury charges, you have to have proof that my allegation.
Filing of a false report. My sincere apology.
But even things that wouldn't rise to the level of a false report. I mean, again, if I make if me and the police officer were the only 2 present that night, and there's nothing else to support my allegations, which would now become the public record. There's no one there to deny it. There's no one to support it. It's the cop versus me, and now every police officer who's involved in any altercation with an angered public, which I dare say they happen probably 4 or 5 times in a shift to every police officer across the state, would now be subject to having their lives ruined by spurious allegations that are not subject to the prosecutor can't prove it didn't happen. I can't prove it did happen, so I can't win on either side. But now the record is full of all these spurious allegations against police officers who are called upon. I mean, I don't get involved in other people's business, but cops are called upon to get involved in people's business and piss them off mightily. And because of that, they're particularly vulnerable to have horrible allegations made against them in the public record.
I'll say this.
I've
had conversations with law enforcement within in Baltimore County. Many law enforcement officers that were opposed back in 2015 when I introduced legislation to do with body cameras. They've come to me now and they have said that they've appreciated having the body cameras on because it's done a great job in ensuring that when there have been false allegations and things made, they could go to the body camera footage. So that would be my response to that.
Thank you.
Mm-hmm.
Thank you, Senator Castley. I know Senator West has his hand up. Senator West.
Yeah, I'm not sure what during session, we take the bills one at a time, and then when the sponsor presents the bill, we get to ask the sponsor questions. I'm not sure how we're working that today. Senator Carter talked about 4 bills. So maybe it's 5 bills, 4 bills, I think, 4 bills. and then I put my hand up at the end, but I wasn't called on. And would I be expected to ask questions about all 4 bills?
No, that's my oversight. I didn't see you raise your hand for the last one, but essentially each senator is going to present their bills and their ideas. And then at the conclusion of their presentation, you'll have an opportunity to ask questions of that senator on their proposals. So now that Senator Sidnor has completed his presentation, welcome to ask him questions. Or if you'd like to go back and you had some inquiry for Senator Carter, since I missed you, welcome to do so now.
Okay. Well, I actually got a lot of questions, and I don't know, should I ask them of the sponsors or should we wait till the panelists come up?
So the sponsors are going to be the ones answering questions because of our truncated timeline. The sponsors will be able to answer some questions if they, they feel like they need to elicit the help of the panelists that come behind them. They can do so, and the panelists will then hear your question and address it in their testimony.
Okay. Thank you, Mr. Chairman. Well, let me start then with Senator Carter. In your first bill, in the first section of the first bill, section 3-2201A and B, are these sections intended to create a new civil cause of action that a citizen could file against a police officer? It appears to me that that's the case, but it doesn't specifically say that the citizen has a cause of action against a police officer for using too much force.
Citizens already have action, so I don't think that the bill is intended to create any new cause of action. It's simply designed to redefine use of force and set certain standards upon which, if they are violated, that citizens would still have the right to file a cause of action. I thought that I also stated that I am actually not locked into this language. In fact, I would choose different language in much of the bill. And so I would be welcome, working with you and everyone else to make it a better bill. There are certain models that I've seen that lay out a policy or a statute that I agree with, that go a little bit further than this bill, and maybe don't distinguish like the differences between the legal standard and the non-legal standard.
Okay, let me go to my next question. Thank you. By the way, thank you for offering to work with us. That's sort of what I was looking for, that these aren't delivered today on a take it or leave it basis, but people are willing to sit down and discuss them and try to work out differences so that we can come up with a consensus product.
As everyone has pointed out, these are not real. So Justin, I think, or Senator Huff, or maybe you said, these aren't real bills. They're draft bills, and they are starting points for us to work out what we think is the best language and the best practices for when we get into session in January, is my understanding.
Okay, that's fair. So in other words, we're not simply going to arrive in January and then have these bills put to a vote.
No, I mean, it's up to the chairman, of course, but I would suggest that we work group these bills.
that over 33 months to do this, and the reason we're doing this now, as I've said time and again, is so that we are well postured to take quick action, but action that we've had an iterative process, a deep dive on all the legislation before us, so we can produce the very best product. But if we wait until the start of session, what happens, and with all the variables, you don't know what's going to happen. So it's a matter of such importance. We're starting early.
Let me keep going. So I'm familiar with the reasonable standard. That's frequently used in the law, reasonable person. But you use the term frequently objectively reasonable, which I'm not familiar with. Is that used in the law currently, or is this a new term that you've put into this bill?
It was put into the bill to the extent that I agree with the bill, which I don't fully agree with the bill. I do agree that an objective standard of reasonableness is better than a subjective standard of reasonableness. Quite often, the law entertains what subjectively the officer believed or thought or perceived as a prerequisite for action. I do believe that an objective standard of reasonableness is a better standard.
Well, the standard of reasonableness is what a reasonable person under those circumstances would have done. So what then would be an objective standard of reasonableness?
So I don't think that's actually the case. I think an objective standard of reasonableness is just in any tort law, the objective standard. But I think subjective reasonableness is not just what a reasonable person would do, but what did this particular officer perceive at the time or believe that he perceived at the time. So that was what I think this was designed to get at, was to move from a subjective reasonableness standard to clearly define an objective reasonableness standard. However, that is not the language that I would have chosen, nor
Okay.
do I stand 100% behind the language as listed, as written.
Okay, great. So we can talk about that. Going down to part B, you set forth a rebuttable presumption that a law enforcement officer use of physical force was not reasonable. So the presumption from the get-go in any trial involving a cause of action against a police officer for using excessive force, from the get-go, there's going to be a presumption that the officer used too much force, correct?
Well, I guess under the current language, that would be the case, but let me just say that.
I'm looking at your language, rebuttable presumption.
So
you're importing a presumption that as the trial starts, the officer is presumed to have used too much force, correct?
what the goal is that if unnecessary force is used, and I've stated this from the beginning, that excessive force is never acceptable, that any force should be necessary, and any force that goes beyond what is necessary is excessive. And so, of course, when excessive force would be used, there should be a rebuttable presumption against that force. I do agree.
Normally in a civil trial, it's the obligation of the plaintiff to prove by the preponderance of the evidence that the plaintiff, that the defendant acted inappropriately, negligently, or unreasonably, or whatever. But it's the first obligation is on the plaintiff's back to prove by a preponderance of the evidence that the plaintiff should prevail. In this case, because you're using the phrase a rebuttable presumption, the initial presumption is at the beginning of the trial that the policeman acted inappropriately, used too much force. That is the presumption, as I understand the language you've used here.
I believe the goal is that of the bill, the language is that if an officer has violated the clear policy, the clear statute, statewide statute on use of force, then that would present a rebuttable presumption that the officer was negligent or used excessive force.
Well, we can agree to disagree on that. I don't think that's what the language says.
Senator West, I know
the officer is presumed to have acted incorrectly and therefore to be subject to a monetary judgment against the officer.
Senator West, I just want to interject here. We're running a little bit behind, so you move off. I know you've got questions. No, but honestly, I want to keep this dialogue going. So encourage you to, engage with the senator after the proceedings and throughout. So I just want to move off the dime. If you've got other questions, we need to move along.
Yeah, I've got a lot of questions, but I don't want to tie up the whole hearing with lots of questions. So as long as we're going to be, maybe I'll ask questions of the panel members as they get into these things.
Got it. And also, if you think of something else, obviously submit them in writing. We'll definitely get, answers, and that'll be another opportunity to collaborate. So, great. With that, do I see any other questions? Senator Reedy has a question.
And I'm sorry if this has kind of been covered, but the one question I kind of was wondering about, because I'm not, the joke in JPR is I'm not an attorney. I always say that, but can I just have a little clarity, Senator Carter, for how would an officer rebut the presumption in this situation if they're in a trial? Because one of the issues is you were mentioning earlier about we don't want them to use more force than is necessary, which I think we all would generally agree with as a statement of principle. But, it's easy to say after the fact that, well, you shouldn't have hit him 3 times with the baton. We don't use those anymore. But you shouldn't have tased him twice. 1 tase was probably enough, or you shouldn't have, whatever. I mean, so even looking at some of the times we've seen shooting, it's like, well, why do they shoot to kill? Why don't they shoot him in the leg? You know, I mean, after the fact, it's easier to make this argument, which is why I believe police officers so strongly argue against a bill like this. So how would they rebut the presumption?
So Senator, I'll say this, but I mean, I'll let Senator Carter answer, but it is actually in the bill. So if you go to page 5 of the bill at the top, the presumption may be rebutted by showing that a particular action that could have been taken by a law enforcement officer was impractical, inconsistent with the program and training that the officer received in entry-level or service training program, training school approved by the Maryland Police Training Standards Commission. So just check that out. That's
I read, and now that you say that, I remember reading it. How would they, if they would rebut that? Okay, all right.
Got it. Okay, great. Seeing no more questions, I'll move on to JPR 6, which is the military surplus equipment, and this will be brief. So in 2019, we passed, actually Senator Lee and Delegate David Moon passed a bill that basically it dealt with the 1033 program, and it was a reporting mechanism so that we could see what the departments across the state, how much they were spending, how much we were spending statewide, and what they were acquiring through that 1033 program that's been, I guess, on the books in Maryland since about 1997. So since then, since last year's reporting, we have $11 million of acquisitions throughout the state. Things like observation helicopters, armored trucks, mine-resistant vehicles, rifles, motorcycles, night vision goggles, Arctic kits, laser rangefinders, and so on and so forth. Even a recreational TV, lubricating oil for tanks and aircrafts. You get the gist. So the bill is pretty straightforward. It's a 2-page bill, and it essentially it doesn't preclude us from entering into acquisition for everything that's available through the 1033 program, but it enumerates what would be prohibited under the bill. So that would be an armored or weaponized aircraft, drone or vehicle, destructive device, a firearm silencer, and a grenade launcher. That's simply what the bill does. Now, obviously, for me personally, I want to ensure that our law enforcement officers have all of the equipment they need to accomplish their mission safely. But when you start blending the military with local, state, and local and municipal law enforcement, I think that runs afoul of what's in the interest of public safety and also what's in the interest of our community's relationship with our law enforcement. So that's essentially the bill. It's pretty straightforward, 2 pages, building off of the good work that Senator Lee and Delegate David Moon did in years past. We have some great data to actually base this bill off of. So those are Maryland numbers. It's pretty straightforward. And I'll yield now for questions. And I see one from Senator West.
Sorry, this is just hopefully a simple question. Senator Smith, can you give us any examples of cases in Maryland when this sort of equipment has been used in a way which you would characterize as misuse?
So yes, there was an armored truck, right? A mine-resistant truck that is sometimes paraded out for force projection purposes, intimidation. It serves no other real purpose but for this militarized facade that's projected to the community. So I would say that would be a prime example. I do want to make one more correction that I did that I had for the initial testimony. So it's $11 million in acquisitions since the establishment or since our enrollment in the program in 1997. So not last year. So from 1997 to 2019, it's about $11 million of acquisitions. So just want to make that correction for the record. I've got in my testimony, which I'm sure that you'll have, it's pretty lengthy. I've got some other examples, Senator West, of, I think, improper use throughout the state. I can make sure you have. Senator Castley.
Thank you, Mr. Chairman. I guess the part of this that troubles me most would be the armored vehicles. I mean, we've had occasion in my county where you have somebody barricaded in a home who's shooting, and the armored vehicle allows the police to approach right up to the home and take action. We've got things like we've got some folks out there like the former Beltway snipers in the DC area. If the police had to confront those people, if they were engage in an all-fired shootout, an up-armored Humvee would be a very nice vehicle to have to simply roll up and intervene. So obviously, we don't want aircraft that are capable of firing missiles and the like, but I don't think we're going to see any of that. But it seems like the bigger piece here would be the vehicles and even grenade launchers. I mean, as you know, grenades come in many different kinds. A grenade launcher allows you to fire simple CS gas to be used in rioting situations. So to deprive police of a basic grenade launcher to launch a CS gas or even a flare for them to use in the event they're searching for people lost in mountainous terrain, to launch a flare through a grenade launcher to locate people kids lost in parks. Is there going to be some discretion here? It's sort of hardcore. You can't have these things. And I know we've been following these things in the legislature for each year, giving us the opportunity to go back and say, why did you get that for? Wouldn't that be a better approach for us just to be able to come back and say, nah, you can't do that, and let them give them the discretion to actually purchase things and justify it rather than to have a preemptive no?
No, that's interesting. I mean, I think that the reason why we've teased out some of the specifics that are outlined in the bill is that because there really is no justification, and that's the policy argument, at least up front, just on its face. So, I mean, armored vehicles, it's different than, we both know this, than like an MRAP or a mine-resistant vehicle. You really don't need that on the streets of Wacomico County or Montgomery County. So that it serves no legitimate public or officer safety interest. And so, I mean, that's where, I think that's on its face, these things should be kind of off the table. But that's certainly something we can talk about, because there are some nuances with when you're launching projectiles. So whether it's a flare or an actual rocket. So I think, there's some nuance there, but the policy argument would be that on its face, these things should be just off the table and should not be in our.
I know, police departments have an up-armored vehicle but it sits in the compound for, almost for a few years before finally there's some sort of sniper situation and it's rolled out, or a hostage situation in a home, in which case it's rolled out, and you can roll in and basically end the hostage situation pretty darn quickly because the police can get within 2 inches of the house, totally protected. Granted, a MRAP's probably a little bit heavier. I'm sure we need too many of that, but certainly the standard up-armored Humvees. I just would like to not deprive our police of the option. I think it'd be better with a board, and granted, people shouldn't be, there's no reason for anybody to be doing your normal patrol in a normal situation through downtown Potomac in an up-armored Humvee and the like. That's not the image we probably want for our police, but I think we ought to be looking at a flexible approach here that allows, because so many of these things can be used for legitimate purposes. Again, a grenade launcher to have for a rural department out in Garrett County to be able to launch up, star clusters and the like, for if you're searching the woodlands and stuff, or even for a riot protection, to have those. Obviously, you keep them in the armory until you absolutely need them for the weapons room. But I hate to see it's just sort of make hard and fast rules that don't give us the ability to our police to react in that one every 5-year event when they really need it, and they're able to diffuse a really potentially tragic situation with a pretty cool piece of equipment that somebody's had to just simply maintain and oil and occasionally drive around the lot to keep the gears going. But it's a well worth the investment because it ultimately can save a lot of lives. So just ask us to look at that. Thank you.
Yeah, appreciated. So with that, if there are no further questions on that bill, that concludes the hearing then for JPR 6. So then we're now going to move to the expert panel. So I'm just going to call folks. Each member of the panel will have 2 minutes to present. And so we'll start off with, I'm just going to go down the line numerically. So we have the ACLU with Mr. Roca. I think I saw him earlier. I see your camera's off, but give him a second here to pop up. There we go. All right. The floor is yours, Mr. Roca.
Thank you, Mr. Chairman and members of the committee. I'm going to go quickly given the limited time. To begin the process of reforming the police, we need to address what the police are allowed to do, what the police are asked to do, how police are held accountable, how departments and chiefs are held accountable for how they police their own, by making that process transparent, and address the need for democratic control over police. The 5 reforms that our coalition of more than 90 community organizations throughout the state have endorsed take steps in each of those areas. There is more that can and should be done, but if we don't do at least these 5 things, we will not have made meaningful steps. Some of today's bills touch on 2 of our priorities: restricting the use of force, namely what police are allowed to do, and transparency in the disciplinary process. We appreciate the recognition of the need to address police use of force. We don't think the proposal before you is adequate. We are going through a deliberate process with our coalition to build consensus around specific language, but have not finished that process given the notice we've had of these hearings. So I will talk today about the principles that are important to us. Existing law in Graham v. Connor looks at whether an officer's use of force, deadly or not, was objectively reasonable from the perspective of a reasonable officer on the scene. That was an improvement over the prior common law standard, which looked at whether officers had acted with an intent to harm and so focused on their subjective motivation. In the context of deadly force in Tennessee versus Garner, the court held that deadly force to apprehend a suspect was reasonable when the officer had probable cause to believe that the suspect posed a significant threat of death or serious physical injury to the officer or others. But that reasonableness inquiry is not sufficiently protective of human life, gives officers too much discretion, and has too narrow a lens that focuses only on the moment that deadly force is used. We think that the law needs to limit police use of force to that which is necessary, meaning that under the totality of the circumstances, there was no reasonable alternative, as quite a few departments now do, like as of the end of last year, the Baltimore Police Department. This broadens the lens to look at whether there were other means of dealing with the situation and requires that those means be attempted if they are possible. And it holds officers accountable for unnecessarily putting themselves in positions where force becomes reasonable under the current standard. In other words, we have to look at whether the force was avoidable. We know that we can do better. We have seen police do better, and we need to now mandate that police throughout Maryland actually do better. I want to say something also quickly about JPR2, the database of misconduct complaints and officers with credibility problems. And the primary thing I want to quickly say about that is that it is not a substitute for actual transparency over police investigations of misconduct. We need to amend the Public Information Act so that investigations of police, like investigations of each of us, are investigatory records that are subject to discretionary redaction or withholding, but only when there is an adequate reason to do so, not categorically barred from disclosure as personnel records. I think that's all I have time for in the 2 minutes.
Thank you, Mr. Roca, and thank you for the work that you've been doing behind the scenes and the work we'll continue to do together. I know that now we have an opportunity for members of the committee to ask questions. So I'll look around, give some committee members some time. I think we see Senator West. He's fulfilling the role of Senator Casserly today with the questions. All right, go ahead, Senator West.
I'm sorry, I was trying to raise my hand, but it's complicated. So
I saw it in your face, so I got you. Yeah.
So Mr. Roca, let's look at bill number 1, which is the bill you mostly talked about. I'm down at subparagraph B on the first page, which talks about the rebuttable presumption. So let me give you a hypothetical case. A policeman is called, or there's a call placed to 911 claiming that a woman's being raped in a house. The first police officer to get there arrives. He sees the back door thrown open. A person runs out the back door and starts taking off into the alley. Now, under those circumstances, the policeman has 2 options. One is to sit there in the car and do nothing. And 2 is to take off after the culprit. So let me read the language in this bill. It says there is a rebuttable presumption that a law enforcement officer's use of physical force or deadly force was not reasonable if, before using a physical or deadly force, the law enforcement officer failed to take every action that an objectively reasonable law enforcement officer could have taken to limit the likelihood that physical or deadly force would be required. Now, taking my hypothetical, if the policeman decides to chase after the culprit there could well end up being a gun battle in the alley. The culprit could have a gun and could turn and fire. The policeman could fire. It would seem to me that under this language, you've got a problem. The policeman has a problem. Policeman has no problem if the policeman just sits in his car and lets the guy run away. Would you agree with me on that? I'm sorry, you're down here at the bottom.
So there you go.
Sorry. I want to be clear. I did not write this language in the bill that we have been discussing within our coalition. Thus far, this language has not appeared. And so I'm not here to debate this language.
I'll accept that, but take my hypo anyway. Apply the language in the bill to the hypo. Wouldn't the police officer be far better advised just to sit in the car rather than run after the culprit and take the risk that deadly force would be required?
No, because obviously it's a police officer's job to apprehend someone who the police officer has probable cause has committed a crime. So that's what we want a police officer to do. Doing that does not necessarily require the use of deadly force. And whether or not an officer uses deadly force in apprehending that suspect should, I think, be judged on whether the use of that level of force was necessary under the circumstances presented when they were attempting to apprehend that suspect.
Okay, but remember, I'm now a plaintiff's lawyer. I'm in court suing the police officer for a very large amount of money, which would bankrupt the police officer and his family. And my argument's going to be using this language that there is a rebuttable presumption that his use of force was not reasonable because he failed to do what another officer could have done to limit the likelihood that physical force or deadly force would be required. Now, why as a plaintiff's lawyer wouldn't I make that argument to the jury? And wouldn't the jury be instructed by the judge with the jury instructions that this is the law of Maryland and the jurors have to apply this law?
I would assume that in order to make that argument to a jury, you would have to articulate what could have been done short of the use of deadly force in order to trigger the presumption. But again, this is not language that I wrote. This is not language that has been part of our discussion. And so I'm not here to defend or attack or whatever this particular language.
Okay, great.
I think, again, I think the principle, which I've heard other members and perhaps even you, I apologize, I am not sure if it was you, say that they agree with, is that we don't want officers to unnecessarily use force. That's why a standard like that is now the policy standard in many police departments, including Baltimore City. And I think that's true of other departments. I know that that's true of other departments around the country. And that is what we think should be the enforceable legal standard.
Okay, thank you very much.
Okay, great. Seeing no more questions, we're going to move on to the next panelist. Thank you, Mr. Roca. Dr. Ray is up next.
Chair, Vice Chair, and the committee, thank you. I'm Dr. Rayshawn Ray. I'm a David Rubenstein Fellow at the Brookings Institution, and I'm also a professor of sociology at the University of Maryland in College Park. I'm the executive director of the Lab for Applied Social Science Research. We regularly partner with government agencies, including police departments, the Department of Homeland Security, and the like. I'm here to talk about JPR 2 and JPR 5. For the past decade, I've done research on policing. And I should also note that I have several police officers in my family. In fact, my great uncle was the first Black chief of police of my hometown of Murfreesboro, Tennessee. And even though that didn't necessarily shape me doing research on law enforcement, it definitely shapes my level of empathy and understanding for the hard work and dedication of law enforcement. The pieces of legislation by Senator Sidnor aims to establish a statewide database for law enforcement officer misconduct and mandates that officers report bad behavior. These are important pieces of legislation that will situate the state of Maryland as being in line with best practices to create equity, transparency, and accountability in policing. Additionally, the Maryland Police Accountability Act of 2021 aligns with President Trump's executive order on policing, as well as the George Floyd Justice and Policing Act, which was passed by the House of Representatives. The George Floyd Justice and Policing Act is significant for many pieces of important legislation, but it is also symbolic for the Maryland Police Accountability Act of 2021. The George Floyd Justice and Policing Act was passed on what would have been Tamir Rice's 18th birthday. He would have been a freshman in college right now. Most of you probably know about Tamir Rice, but the state of Maryland, our great state, has its own example. In September 2018, 19-year-old Anton Black was killed by Greensboro police officer Thomas Webster. Webster previously worked as an officer in Dover, Delaware, and left the department after a dash camera showed him kicking an unarmed Black man on the ground and breaking his jaw. Webster was acquitted of assault, but he ended up leaving the department. After a settlement with the city, Webster was banned from seeking employment in the city of Dover. He then came to the state of Maryland. Collectively, my research indicates that Anton Black, similar to Tamir Rice and George Floyd, will still be alive today if this legislation had been in place. This is how bad apples end up rotting the tree of policing. When people apply to be a police officer, part of their background check should be ensuring that they are not on this list. Officers should be placed on this list if they are found liable of misconduct or resign at the time of investigation of misconduct. That's very, very important. My research indicates that's a key way that officers end up going around from department to department. These pieces of legislation, in particular this database, should include reporting at the state level to have additional accountability beyond what happens within departments or local municipalities. State oversight also protects officers who report bad behavior. Officers who wish to report bad behavior should not face stigma and sanctions for doing what cops should be doing, which is monitoring bad behavior and ensuring that wrongdoers, whether inside the police department or outside, are held accountable. My research shows that officers who report bad behavior are less likely to be promoted, more likely to be transferred, and more likely to face internal stigma and sanctions. This is the case with a group of officers in Prince George's County who bravely spoke up about racial and gender discrimination within their department. In closing, Maryland can be a leader in establishing statewide databases for misconduct and mandating reporting by law enforcement. Eventually, this will become commonplace at the federal level, and the senator's legislation places Maryland as a national leader in this space. Thank you.
Thank you, Dr. Ray. We are looking for questions. There we go. Senator West has a question.
I guess I am playing Bob Castley today, aren't I? The committee will know what I'm talking about there. So I'm with you up until you see the word alleged. So this data is to be made available to anybody who wants it, correct? Any member of the public can get this data. Newspaper reporters, advocates, ordinary citizens can get their hands on this data, correct?
So I don't know if you're talking to the senator or me, but if I...
No, I'm talking to you.
Okay, yeah, I don't think I said alleged. I actually wrote down exactly what I said, and that wasn't a word that I used.
Well, I'm looking at the bill.
If I said that,
you're talking about bill number 2, aren't you?
Yeah, but I'm saying in my testimony, I didn't use that word.
Okay, but I'm looking at the bill. Your testimony is great, but we're going to pass a bill. We have
right.
actual language.
I was just making sure. That's why I was asking who you were directing it at, because I said I didn't use that word. But I can talk about the legislation in the bill about the alleged comment.
Well, yeah. Do you support the inclusion of the word alleged in the bill?
I think what's important is to have a database where officers have been found liable of misconduct and or have resigned at the time they have allegedly committed misconduct. And I think that's something that this body, I agree
with you on that.
Yeah, and I think that's something this body really wants to do. And I would imagine that what the senator was saying with the alleged comment is ensuring that officers can now resign, come from where I'm at in the state and come to where you are in the state. And so I know that you all just talked about having a discussion.
That's what he means. That's not what the bill says. The bill says that any allegation of misconduct is available to the public and anybody can get at it. It's a little like making your personnel file available to the public. Most people would not want their personnel file to be made available to newspaper reporters or anybody else. That's why I'm worried about the word alleged, because it's a little like the FBI, raw FBI files. They're full of allegations which have not been proved. I just think would be reprehensible to subject police and their reputations to having any allegations spewed out there into the newspapers, et cetera. So if you agree with me that the word alleged should not be used in the way in which it's used in this bill, we can stop this conversation.
Well, I'll tell you what other places around the country are doing, because I regularly testify on policing across the country, including several in this region from Virginia to Pennsylvania. Arizona is a really good example that Maryland might want to look at. So they put together a database of allegations, but those allegations aren't tied to officers publicly. So in other words, people internally still know who the officers are tied to, but it creates a list of these misconduct allegations. And then still at the state level, it has a list of officers who have been found liable or who have resigned at the time that they were under investigation, which I think is a key piece of legislation that from President Trump's executive order to the George Floyd Justice and Policing Act includes.
Great. I see in Senator Sidnor's testimony that former Baltimore County State's Attorney Pat Jessamy maintained a list of officers who, quote, engaged in conduct that is so egregious that it undermines the due administration of justice. And she wouldn't put those people on the stand. I completely agree with that. But to suggest that if there's a mere allegation of incorrect conduct, that would undermine the credibility of a policeman. It's never been proved, never been established, just a mere allegation. I draw the line before that point. I don't know where you are on that.
Yeah, so one of the things that the research shows is that if we take an officer like Derek Chauvin, he had 18 complaints, but most of these complaints were never founded. Some of them were actually. So if we go back in time, some of them were. So he would have been on the list at the state level, but most of them were not. And overwhelmingly, of course, law enforcement will tell you that it's a small group of officers engaging in a large amount of misconduct. And they oftentimes don't want them in their department either. So we know these officers are able to use the law. I mean, a lot of officers who I know have 10, 15 complaints. I mean, if we look at the recent killing in Prince George's County, that officer had been involved in 2 previous deadly force incidents. And so there is a pattern here. And I think part of what you all, as our elected officials, have to distinguish between is making this information transparent and public, but then also ensuring that bad apples don't continue to rot in the tree of law enforcement while good officers are out there trying to do their jobs.
I completely agree with you. Thank you very much.
Thank you.
Thank you, Senator West. All right, and this is my fault. So what we're going to do is we're going to go through the rest of the panelists, and then we'll save questions till the end of every panelist. Okay. So Senator West, if you could, write those questions down, record them for the end. So we're going to streamline things a little bit. Okay. So now we're going to go to Mr. Williams, Kenneth Williams. Is Mr. Williams here? All right, going once, going twice. All right, we're going to go to.
I'm mute.
Oh, there you go. Now? Got you.
Okay, great.
There you go.
All right, great. Thank you. Thank you, everybody, for having me today. Today's Bill JPR 1, I support it. It's based on use of force standards. Based on use of force, officers are trained that reasonable force is force which is objectively reasonable under the circumstances, and it's the minimum amount of force necessary to effect an arrest or protect the officer or other person. Officers must be held accountable for use of force that is not objectively reasonable or otherwise violates law or policy. The bill itself, JPR 1, addresses certain standards that have to be looked at that address the proper use of force by law enforcement officers. It also addresses the fact that officers are the people who assess the objectively reasonableness of an officer. And based on that, it's also talking about the fact that what is not reasonable. And when we talk about reasonable force, reasonableness is based on the facts of what an officer sees, hears, tastes, touches, or smells while they're at that scene. And other officers come along and they assess, in hindsight, what that other officer did without trying to inject other facts or circumstances that may not have been in play at that moment in time in assessing that. So, based on how the bill is written, I do support the changes in the use of force standards.
All right, thank you, Mr. Williams. We are again going to save the questions to the end, so we'll now move on to Sonia Pruitt. Ms. Pruitt.
Good afternoon. I am here to speak on JPR 7, which speaks to the whistleblowers protections. I am a retired captain from Montgomery County Police, currently a professor at Montgomery College in the discipline of criminal justice, past chairperson of the National Black Police Association, and also a speaker with the Law Enforcement Action Partnership. In the police reform conversation, one of the most important efforts towards accountability is to provide good apples protection to report what many in policing are calling bad apples, and to make the report without fear of retaliation, repercussion, reprisal, harassment, or unequal representation by police unions. Currently, the ability for officers to report misconduct or even bad behavior is hindered by police culture. Police culture says that you remain loyal to the blue at all costs, and if you do not stay in line, you can find yourself isolated, not supported or backed up on calls for service, harassed, discriminated against, and even threatened. The fear of reprisal, means good apples remain mostly silent. I testify on the subject because I lived it. I don't have enough time today to share much of my story, but I will tell you that early on in my career, when I complained to my superiors about certain unethical race-based behaviors that I observed in the police department, my efforts were met with a variety of responses: disbelief, disdain, distrust of me, resentment, hatred, harassment, and disregard, and threats towards one of my family members. But it was never taken seriously other than that. As a result, for the next several years, I was met with various roadblocks, challenges, and microaggressions, not of my choosing or making, but that were clearly designed to mute me, minimize my education skills and experience, and to derail my successful matriculation as a police officer, and even to attain rank. One of the last insults I experienced before retirement was to make history as the first African-American woman police captain in Montgomery County, and then to be sent to a midnight shift as duty commander, while my younger and less experienced peer, who was promoted to captain at the same time, was assigned to be the director of the police academy. I was told it was for the good of the organization and that everybody got their turn. That was not true. The experience was traumatizing. Yet during all of those years, I did not complain, as there was no one to complain to, and I did not expect results even if I did complain. So I worked through the challenges, broke the glass ceiling, and attempted to assist others who were having similar experiences. I wish that there had been the option of filing action under whistleblower protections when I was a younger officer, and perhaps my journey would have been different, more positive, more sustaining, more uplifting. I don't know, and I can't know now. But I want to thank Senator Carter, Senator Sidnor, and the entire Judicial Proceedings Committee for the hard work they put into this and other police reform bills. In particular, to suggest that the Attorney General's office play an independent role in the handling of whistleblower complaints is a phenomenal decision and goes a long way towards reimagining policing in the state of Maryland. To combine whistleblower protections, duty to intervene, and duty to report misconduct are an appropriate partnering in the accountability effort, in my opinion. So finally, I want to thank you for allowing me to share my personal story to some extent. I testify before you today, not from a victim stance, but because it is true that there is no testimony without a test. But it was not easy by any means, and I hate that our ability to diversify police departments hinges on what happens when those new and excited officers are absorbed by current police culture. Right. I say this in representation of all of the many police officers of all races and gender identities that need to know that in the chosen profession of law enforcement, which speaks to the protection of the people, that they too will be protected. And in addition, this bill is in keeping with the various oaths taken to become sworn officers and mission and vision statements that usually speak to the integrity with which police should serve.
Thank you, Ms. Pruitt. that concludes testimony there. I know that I was just informed that Mr. Williams he didn't have an opportunity to testify in the whistleblower portion. So Mr. Williams, if you want to complete very succinctly, go back and provide your testimony there. And then for the rest of the guests, we just want to make sure that we keep to that 2 minutes. I want to make sure we're all fair, but people are running up against it. So if we could just keep the 2 minutes, that'd be great. Oh, 4 minutes. There you go. I know. All right. 2 minutes. So Mr. Williams, you have a brief addition to your testimony?
Yes, thank you. I do appreciate that. With respect to JPR 4, duty to intervene, I would like to address the fact that as a police officer, former member of law enforcement, it's very important as my written testimony states, if a patrol officer fails to intentionally and knowingly recognize excessive force and does not intervene to stop any officer from using excessive force, then that officer should be charged with a crime and fined as outlined in JPR 4. Likewise for a supervisor. The supervisor, if they fail to intentionally and knowingly recognize excessive force and does not intervene or report brutality, then that officer should be charged with a crime and fines as outlined by JPR 4. These standards, in looking at the Department of Justice consent decree, which the Baltimore Police Department was subjected to, a lot of these standards are fleshed out as a best practices in that consent decree. And I would state that would help, with professionalism in law enforcement with respect to duty to intervene. The next one, JPR 7, whistleblower protections. It's important, very important, especially for law enforcement officers and civilians alike who report misconduct. For law enforcement officers who report misconduct up the chain of command, they should not be subjected to some sort of tactic that's going to try to chill their speech. Every officer, regardless of the rank, who observes or becomes aware of any act of misconduct by any officer against a member of the public should be required to also report that incident to a supervisor. That too is a standard that is adopted in the DOJ as a best practices standard in the consent decree. The DOJ says explicitly that bullet A, where an act of misconduct is reported to a supervisor, the supervisor shall timely document and report the information up to the OPR. That B, failure to report any allegation of misconduct as defined in a consent decree agreement will be considered a misconduct and will be subject to discipline and or appropriate corrective action based on the seriousness of that conduct. And bullet number C, all forms of retaliation, interference, intimidation, coercion, or adverse action against any person, civilian or sworn officer who, because that person reports misconduct, attempts to make or makes a misconduct complaint or cooperates with an investigation of misconduct, are strictly prohibited and shall result in discipline, demotion, and appropriate correction action based on the seriousness of that conduct. Also, in closing, JPR number 3, which is the no-knock warrants elimination bill, I strongly support it as well because as a plainclothes detective, I know all too well, based on the many warrants that I have served out in the community, that no knock and announce warrant is a very, very dangerous position to place citizens on the other side of the door in, as well as police officers who are on the other side of that door looking to gain entry. I know all too well, based on my own personal experience and observations as a law enforcement professional, that a no-knock warrant tactic can startle the people into unplanned reactions. The outcome is increased risk to law enforcement officers and civilians. For these reasons, I support eliminating the no-knock warrant. Thank you.
Fantastic. Thank you very much. Okay, now we're looking for is Tyrone Powers in the room? Okay, so Tyrone Powers is not here. We'll then move on to Mr. Franklin. If you'd like to provide your testimony.
Sure. Thank you, Mr. Chairman. I'm going to be speaking to 5 pieces of policy, 1 through 5. And let me begin with, and I think many of you here know me. I know a little bit of my background. I'm a 34-year police veteran, retired from the Maryland State Police as a major. I've served as the head of training for both the Maryland State Police and Baltimore Police Department. Today, I'm representing the Law Enforcement Action Partnership, of which I'm the executive director. I've been there for 10 years. I've also been working on police reform policy here in the state of Maryland, actually with Senator Carter going back almost a decade. So that's just a little bit of background regarding me. Regarding JPR 1, which is excessive force, basically what we're merely requiring police officers to do what they are trained to do in line with policy. For example, number one, from the very moment you arrive on the scene, you search for opportunities to de-escalate. We're trained to de-escalate using a calm demeanor, listening, monotone voice, respect, dignity to gain compliance. And that's what this bill does. It considers the actions that you take or do not take prior to that moment to where you have to use force. Number two, we train officers to do things like seek cover in potentially dangerous situations, adding that crucial decision-making time so that they can better assess a situation before they respond with force. So we train you not to place yourself into those positions where you have to use deadly force prematurely, like stepping in front of an occupied vehicle or reaching into a vehicle that is running and still occupied. And if force must be used, to legally control someone or to take some legal action, according to your training and policy, then abide by the use of force continuum, which I believe was already spoken to. So I support this bill. The organization supports this bill in its current form, but ideally, the reasonable standard should move to a place of necessity standard, a last resort. This is similar to model policy that's being pursued across the country, state by state, which was already mentioned. I just want to speak to this example in California. San Francisco moved ahead of the state of California regarding this standard. And over the past couple of years, they've already experienced and seen a 47% reduction in use of force cases by police. And police are not being harmed more. And it makes for a safer situation for the police as well as everyone else involved. JPR 2, credibility as witnesses and misconduct databases. Basically, police officers have great power. And, in our cities and in our counties, police officer integrity and credibility is most important. It's an essential job function. Police officers enforce the laws, they arrest people, they charge them, they have to testify in court. People are convicted, resulting in that person's liberty being revoked by the state, therefore incarcerated. In a country where we're established on a foundation of such freedoms and liberty, untruths in our courts cannot be tolerated, and they should not be tolerated. And we have to have a process, a system for tracking officers who have integrity issues and truthfulness issues. And when that credibility is lost, ideally they should be terminated and permanently decertified and not able to go from one department to the next, or even from one state to the next. JPR 3, no-knock warrants. I think this is very crucial. Straight to the point, quick history. There was a time, I was responsible for serving search warrants, approving search warrants, and actually almost 100 throughout my career, where I've denied requests for no-knock search warrants because there was no clear need, there was no reasonable expectation that there would be violence or that the evidence could be destroyed that we were trying to seize. Judges years ago used to deny these warrants all the time, but we've gotten to a place where they're just being approved and we're using SWAT teams more than we need to for dynamic, violent entries, and people get hurt. Just one example, I think many of you are familiar with Mayor Calvo in Berwyn Heights. Yeah.
I'm sorry, we're well over. I just wanted to, if could succinctly conclude. I'm sorry to interject, but I know.
Duty to intervene is a no-brainer George Floyd situation. Now I can speak to these in Q&A. Duty to report and whistleblower, as already has been mentioned, they all should be combined. So duty to intervene, duty to report, and whistleblower should be combined. I'll stop there and answer during Q&A any questions.
I appreciate that. Thank you.
Yep.
Okay, Ms. Roth, Chrissy Roth.
Can you hear me?
Yes, there we go. We're good. How are you?
Okay, fantastic. Thank you. Chair Smith, Senator Carter, and committee members, thank you for having me here today to weigh in on JPR 1 and police use of force. My name is Christina Roth, and I am Amnesty International USA's senior advocate for our criminal justice program, leading our work to stop unlawful use of lethal force by police. In 2015, AIUSA published a report finding that no state in the US nor our federal legal standards meet international law and standards for police use of force and firearms that the US is obligated to uphold. In Maryland, between 2013 and 2019, 128 people were killed by police, 80 of them Black. In these years, Black people accounted for 29% of the state's population, and yet 63% of the people killed by police. Maryland remains one of 9 states, as Senator Carter noted, in the US, including Washington, D.C., without a police use of deadly force statute. JPR 1 would enact a felony assault statutory penalty for officers that violate the existing legal standard in Maryland and training, police, or written orders by intentionally using excessive force. While Amnesty shares in the goal of preventing unnecessary force that involves police, we do not believe this bill contains sufficient limitations to the use of force in order to yield that result or provide for accountability when those incidents occur. JPR 1 maintains what Maryland courts have applied from US Supreme Court cases defining the minimal constitutional limits of police use of force, Tennessee versus Garner in 1985 and Graham versus Connor in 1989. While Graham's reasonableness standard is the foundational framework and widely accepted by law enforcement, some states and jurisdictions use of force statutes and policies incorporate additional elements that bring important clarity and even push beyond the floor set by these cases. Maryland must follow suit and enact statutory limitations to the use of force by police that prohibit deadly force unless necessary as a last resort to prevent an imminent threat of serious injury or life after exhausting reasonable options. We've joined more than 90 advocacy organizations, survivors of police violence, and concerned Marylanders in this demand, and 4 others for the 2021 legislature to further police accountability. Though we're disappointed to see that such demands are not fully reflected in the package of bills before the committee in coming days. We all want to see our loved ones come home at the end of the day, and enacting statutory limits to police use of force can help ensure all Marylanders have a right to safety, including law enforcement. Thank you for your time, and I look forward to your questions.
All right, thank you very much. Next, we have Ms. Ryder, Kimberly Ryder.
Thank you. I'm going to be speaking regarding JPR 3. My name is Kimberly Ryder. I'm with the Office of the Public Defender. I'm a supervising attorney in Prince George's County in the felony division. And what I would say is that as an experienced attorney, I rarely see no-knock warrants. Usually we're seeing warrants that, were signed off on, and the officers will announce who they are. Senator Carter mentioned in the bill that, 1, we have to be concerned from the perspective of the people in the home in which the police are executing a no-knock warrant. Those people may be afraid that there's a break-in. And she also mentioned the fact that there's an inability of the officers to correct inaccurate information. As a supervising attorney, I have sat and watched in court. I have heard attorneys who are trying to suppress evidence that's collected. And I want to give an example that really illustrates these issues that Senator Carter brought up. There is a case recently that there was a no-knock warrant that was executed in Bladensburg. It was executed, it's a family home, townhome, where a client of ours was living with his godparents. He was sleeping on the couch. At 5 a.m., the police came in. They used explosives to blow the front door. They also used explosives to blow up the basement, and they entered the house from both directions. There are young children in this house. There was a 3-year-old child and there was a 10-year-old child. Both were awakened by officers storming into the house, and both who've suffered trauma since then as a result of being awakened in these early morning hours by the police. That was a very scary situation for them. The police didn't find what they were looking for. The client was being represented by our office in another case. That no-knock warrant was achieved. The officers were able to get that no-knock warrant by relying on a confidential informant who indicated that the person in the house was up to no good. And as Senator Cassidy had pointed out previously, sometimes things are just rumors, they're guesses, they're speculation. There wasn't a lot of information for the police to be obtaining that no-knock warrant. But even more of more concern, on September 10th, 2020, the police executed another no-knock warrant on the very same townhome. The big problem was the target of the investigation wasn't even living there anymore. He had moved out, he was living with friends, he was no longer living with the godparents. So again, at about 5 o'clock in the morning on September 10th, just a few weeks ago, the police used explosives again to blow off the front door of this house, to blow off the door of the basement. The cat got out. It created electrical issues where the lights in the front of this house don't work. Apparently, their younger child, who's now turned 5-year-old girl, is getting counseling. She was already getting counseling related to trauma from the first entry of the police into the home unannounced. She's getting further counseling, and she's scared to go to the bathroom by herself. She's worried the police are going to come storming in with guns again. This isn't the type of thing that should be happening. The police should have to announce themselves. And the heartache and trauma and reputational damage to this family, it goes to both that inability to correct inaccurate information. The target of the investigation wasn't even living in the house. And it goes to not only the fear that it's a break-in, but when you see people pointing guns in your face, especially when you're a 5-year-old child, that's really scary. Thank you.
Thank you, Ms. Ryder. And next we have, to round out OPD, Ms. Levy. Deborah.
Hi, my name is Debbie Levy. I'm the Director of Special Litigation from the Office of Public Defender's Baltimore City Felony Trial Division. Chairman and committee members, thank you for having us here today. I'm going to be succinct and give you 2 minutes of testimony on JPR 2 and 2 minutes of testimony on JPR 5. In 2015, and first is JPR 2, which, as everybody is aware, is the misconduct database. In 2015, Jamel Rayam testified in the Baltimore City Circuit Court in the case of State of Maryland versus Gary Clayton. At the end of that proceeding, Judge Barry Williams found Officer Rayam, then Officer Rayam, to be completely and entirely not credible. That should have been reported to a centralized database, but it wasn't. What Judge Williams also concluded was that another witness was actually credible, as she described what happened to her on April 8th, 2015, when Jamel Rayam and his colleagues broke into her home without a warrant, held a gun to her temple, handcuffed her and her boyfriend, and rooted through her belongings. You had a chance, if you were a lawyer in Baltimore City, to find out about this gross misconduct if you either A, got a sanitized disclosure from the state, which didn't always happen, or B, were friends with the defense attorney, Stacey Pipkin, who shed light on this misconduct in her client's case. Around the same time, in another case in Baltimore City, a client of mine was held without bail for an entire year, looking at life in prison for an attempted murder. A year into the case, we found out that one of the detectives, Jeffrey Converse, withheld negative photo arrays, instances where victims of the shooting couldn't identify my client or said he wasn't the shooter. Judge Charles Peters said it shocked the conscience and precluded that detective from testifying in the case. But there was no other centralized repository for that information and no other consequence.
Ms. Levy, I have to just interject 1 second. Everyone's getting 2 minutes, not 2 minutes per, so not 4 minutes total, just 2 minutes. Just want to make sure that's clear with everyone.
Well, I was 2 people today and we changed.
Is that right? Okay. You're representing 2 people? Okay.
Yes. Mm-hmm.
Proceed.
You made a schedule change? Perhaps if there had been, government agencies would not be facing millions of dollars in lawsuits for the Gun Trace Task Force, and my client would have not sat in jail for so long without seeing his family. Perhaps if there was a centralized database, officers wouldn't be able to walk into court and testify in the next case with no consequence. Disclosures would not turn on the whim of an individual prosecutor or the goals of an elected one. We know we need reform. We know there is a culture of silence, and we know that officers not only act in their own jurisdiction without consequence, but travel from one jurisdiction to another with no record following them. Those who act well and with honesty should not be worried about tracking the acts of those who do not. If you give me the courtesy of the schedule change for I was a second person today who I am now myself, understanding that you're behind schedule, I'm going to give you 30 seconds of the next clip for reporting misconduct.
Appreciate that. Thank you.
2017, Richard Pinheiro was accused of and convicted for planting evidence. All of you have probably seen the body camera footage. It was disturbing. What was more disturbing on the body camera was the two officers who laughed out loud as he said he was going to do it. There is no culture of reporting. The other officers who laughed at him, who swore out a statement of probable cause, act without any impunity or any consequence whatsoever. As lawyers, we have an obligation legally to report misconduct when we see it. So too should police officers. Perhaps it's what's needed because the honor code itself just is not working. I will submit the rest of my comments in writing.
Okay, thank you very much. Thank you, and apologies for the confusion. So thank you. Next, we'll go with J. Wendell Gordon. Mr. Gordon.
Yes, thank you for having me. I want to say thank you to Mr. Chair. Thank you to Jill Carter for allowing me to participate and inviting me to this very important discussion. My testimony is in support of public safety, JPR 1, JPR 3, 4, and 7. However, I'm in agreement with all the policy changes that are up for discussion. I appreciate everyone being here to actually take part in trying to find some balance to make this thing fair and equitable. I want to say that in terms of the use of force standards, I think it's very necessary that we dispel the propaganda that there's no need for change and that we're looking for better ways to perform broken. There is very much so a need for change in this area. I appreciate and recognize the thoughts and guidance provided by the ACLU with regard to the use of force. That necessary force should be the standard as opposed to the currently standard that's in place. No-knock warrants. I don't think at this point in time there's a need for them. They're very dangerous, and I can think of a few situations where a no-knock warrant has caused grave injury, and sometimes the injuries that we're talking about don't come in the form of broken bones, but they come in the form of broken spirits. They come in the form of emotional distress, the trauma that many of us have to deal with long after the police officers have left the house, long after they've raided the house and discovered that there was nothing there incriminating, no contraband or things of the like, and long after we are left to put the pieces together after our whole lives have been taken apart. So I really see the elimination of no-knock warrants to be something that's not only helpful to police, but also helpful to everyday citizens. The duty to intervene. Recently in Baltimore City, there was a woman that was decked by police. And in Baltimore County, there was a woman that was hip tossed, a 76-year-old senior that was hip tossed by a Baltimore County officer. And as far as we know, if there was a duty to intervene to prevent some of these things from occurring, we probably wouldn't have had these situations. If there was a duty to report the excessive use of force, we probably wouldn't have had these situations because officers would be thinking reasonably instead of thinking about how they can get away with or being able to get away with this unbridled misconduct. So we do need to bring in the controls of officers and provide some accountability to the public. JPR 7, law enforcement officers whistleblower protection. Well, that goes without saying. We know about how police officers who are treated good, those who actually want to do good by law enforcement standards, and they all of a sudden find themselves in very difficult situations because they decided that, you know what, this is wrong and I need to do something about it. As we have it today, you know, officers tend to look at people like me, African Americans, as fitting the description. Well, officers fit the description because they wear the same uniform. We can't tell one from the other. We can't tell a good one from a bad one. So we need these whistleblower protections so that good officers can stand on their merit and bad officers can be rooted out of the force based upon their own demerit. So I'll state in military surplus, that's not one I'm necessarily in on, but I do appreciate the fact that we don't need armored personnel carriers. Corinne Gaines was a young mother killed in Baltimore City by Officer Royce Ruby. They had an armored personnel carrier up against her patio. They had snipers outside of her door. They had all the officers regaled in body plates, armor, helmets, sidearms, as well as AR-15 rifle. They had 38 officers surrounding the perimeter of her place. She had, according to the officers, a shotgun and a sundress on. Okay, do you really need an armored personnel carrier for a mother of 2 babies to be parked outside of her house to feel safe when all these officers went in a safe location and the jury so found and awarded a substantial amount in damages because of the wrongful death of Corinne Gaines? So with this military surplus, look, this surplus, this is military equipment, is for war. And we all know war is not about who's right, war is about who's left. And I submit to you that we do not need to wage war on the citizens of this great state of Maryland. Mr. Chairman, Vice Chairman, Jill Carter, and everyone who's in support of these discussions that need to be filtered out so that we can come about with some good legislation that's going to help the people of Maryland. I thank you all. Thank you.
Thank you, Mr. Gordon. Really appreciate your testimony here today. Next up is John Neske. Chief Neske, you have the floor. 2 minutes.
Thank you. We appreciate the opportunity to represent the hardworking women and men of law enforcement in the state. And we really do commend you for having these discussions, having everyone at the table, getting the varying points of view, because believe it or not, at the end of the day, law enforcement as a profession wants to be at the same goal as everyone here. We want transparency, we want accountability, and we want fair and equitable treatment of our residents. That is our goal, that is our mission, that is why we signed up for what we do. So while we support a lot of the common ground, a lot of the concepts behind this, we do have some suggestions and some tweaks possibly about some of the language in some of the bills. So I'm going to discuss number 7, whistleblower protections. We are in agreement with that. We should have a culture where officers are comfortable reporting misconduct within the organization. Because again, as supervisors and administrators, we can't see every single interaction. We can't see every nook and cranny of our department at all times. It's important that our officers are comfortable in reporting misconduct. So we'd also like to talk about JPR number 2, which is the database. We agree in concept. We agree that there should be a database. We agree that there should be a singular location where everyone has the same information. Some of the places where we want to take a look at is making it a public database. A reference was made to the judicial accounts or judicial databases that are out there for people who have been charged or anything like that. Well, the problem with that is, and the main difference that I see is that these people that are in the public databases for charges have met the probable cause standard. As was referenced earlier, anybody can say anything at any time about an officer. We want to look at these complaints, but if they're straight lies or spurious comments based upon revenge on a charge or a stop, we want to be careful about ruining the reputation of a good officer who may have just been lied upon or someone made a false complaint about him. And again, one of the things that Dr. Ray mentioned was that they're sustained complaints. So we want to be able to do that. We talked about resignation in lieu of termination. None of us want to put bad officers in our department. For every great officer we could have a department full of great officers. We have one officer that is not great and is doing the wrong thing. It brings our entire department, our entire profession down. And that's something we truly want to protect. So one of the things that we can look at is the MPTSC has a database now of officers that have been terminated or that have resigned with charges pending. Maybe we can expand upon that. We are all in for a database. It's just a matter of tweaking some of the details. And we are before you ready to move forward. We are anxious to help you make this happen. We agree that there needs to be change, but we just want to make sure that we're part of this conversation, that we're fair to both sides of this equation, and that we give our best to both the police who are serving the community and the residents that we are serving. And I believe that we can do that. So thank you for the time and consideration.
All right. Thank you, Chief. And next we have Commissioner Harrison.
Good afternoon, Chairman Smith, members of the committee. I appreciate you giving me the opportunity to speak with you today. As I am aware, I'm likely the only police chief in history to lead 2 police departments under a federal consent decree. And as such, I'm committed to reforming not only the BPD, but leading the way in reforming the policing profession at the local, the state, and even the national level. As I'm part of 3 different executive boards working on police reform, and I truly believe that with some policy changes, we will be able to be more accountable, more transparent, and we will develop stronger lines of communication and trust with the residents we serve. So I'm going to be focusing my remarks on 2 proposals being considered today: the duty to intervene and the duty to report misconduct. Both of these responsibilities are important aspects to changing the culture of law enforcement into one that embraces accountability and should be a part of a statewide use of force policy. The duty to intervene that is embraced by all members of the department and that is enforced will allow us to help prevent physical and emotional injury to members of the public, and then show the community and our officers that we care about their well-being. That will go a long way in building community trust, and that trust is essential to becoming a more efficient police department. Now, the Baltimore Police Department has already fully adopted the duty to intervene in policy and is in the process of bringing the nationally recognized program called Ethical Policing is Courageous, or EPIC, to the department, which is created in New Orleans when I was the chief there. EPIC is a peer intervention program that emphasizes to all members that regardless of rank, those who observe their fellow officers potentially going down the wrong path should intervene to prevent the bad acts before it occurs. So programs like EPIC are an essential part of improving culture of a law enforcement agency, and it sends the right message that we have an obligation to the public and to each other to prevent misconduct when possible. So laws that require this can have a similar impact on culture change, and that's why I am and we are fully in support of the proposal you're considering today. And at the conclusion of this hearing, my staff will send you all the policies dealing with the duty to intervene and the draft curriculum for the EPIC program. We also support the duty to report misconduct. As officers of the law, we are duty bound to report crimes whenever we observe happening in the general public, and the same should be true for acts observed by fellow members of law enforcement. So I recommend that there be an amendment added to the proposed bill that also includes an agency's internal affairs function as one of the places where an officer can go to report misconduct. Baltimore Police and many other agencies already require this in policy, so providing a law for the same is just an extension of that requirement. We must all work together to achieve the common goal for changing the culture and embracing accountability and transparency. Because as you know, accountability without transparency is not accountability at all. I stand ready to work with this committee and the rest of the General Assembly to ensure that as policing reforms are being considered, we ensure that we're thoughtful in working to pass meaningful laws, but we also have to be aware of unintended consequences on moving on legislation that requires future review and discussion. Thank you again for your time and for your attention.
Thank you, Commissioner. Next, we will have Mr. Davey.
Good afternoon, Chairman Smith and members of the committee. For those of you who don't know me, I am General Counsel to the Maryland State Fraternal Order of Police. Briefly, in my background, I'm a retired captain from the Maryland State Police. And for the past 21 years, I've been representing police officers throughout the state of Maryland. My firm currently represents approximately 53 police unions throughout the state. And I represent many officers in those organizations. The FOP completely understands that police accountability is a concern for many Marylanders, but we also understand that legislative bills will be presented in the General Assembly for more police transparency and accountability, and we know that this week's hearings are just the start of those discussions. The FOP wants all of you to know that we're not going to oppose and object to every change. However, we will oppose some and submit amendments to others. The FOP is very thankful for your committee, has given us the opportunity to express our concerns and ideas, and we look forward to these productive discussions continuing into the legislative session. 2 minutes is clearly not enough for me to discuss 7 bills that have a major impact on law enforcement throughout the state. So I will stand by and answer any and all questions involving all 7 of these bills. Thank you.
All right, thank you very much. And then next we have Mr. Rose, Dave Rose.
Good afternoon. Just want to reiterate what Mike Davies said. Sorry, I had to unmute. Yeah, I just want to reiterate what Mike Davies said. We understand the conversation that has been taking place, and we're here to be productive and add vital input to some of the construction and conversation that's going on as we move forward. And I'll stand by to answer any questions about any of the bills that we have here, because like Mr. Davies said, 2 minutes is not enough time to talk about the issues in many of these bills. I do want to say that the JPR number 7, the whistleblower bill, it looks very familiar, and I am in support of it. I actually had reading the bill over the weekend, actually looked at a draft that I had back in 2016, and it is almost verbatim as to the bill that I had drafted and submitted in 2016 in reference to providing whistleblower protection for our members. The one issue I did see that we had a difference on was the referencing to going directly to the Attorney General only. And I would say that the local jurisdiction should have the opportunity to report something to their local attorney, because there are some smaller jurisdictions that might not have a grasp on the Attorney General process, and they might be more prone, or I guess willing to speak to their local state's attorney or county attorney. But I'll stand for any questions on any of the other bills anyone may have.
I appreciate that, Mr. Rose. Thank you. And then last but not least, Mr. Schellenberger. There you go.
Mr. Chairman, members of the committee, thank you so much for having me on. And I would actually appreciate the use of the Neil Franklin timer, which is 4 minutes and 50 seconds. So just kidding.
I knew you were going to say something like that.
You know it's coming. So at the outset, I would like to say it would be easy for me to be up here and say oppose, 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 but I am not going to do that. I offered written testimony on 5 of the bills. I believe on all 5 of them, I offered some amendments that I thought were important, and I'll briefly touch on those, but I stand ready, willing, and able to talk to every one of you and work with you to get to a place where we can all be relatively satisfied. Many of you I've worked with on many bills, Senator Waldstreicher on expungements, Senator West, I sat next to him that whole day on JRA that Saturday. So JPR number 1, was the force reasonable? The first part of the bill makes it seem like it's dealing only with civil. And if that's the intent of the bill, then I certainly think it needs to be cleared up a little bit, because when it later talks about the force needs to be reasonable and then starts putting presumptions in, it does not seem as if it's limiting itself to civil law. The other thing that's important is presumptions in the law, if a person is a defendant, could prove to be a real constitutional issue that could be taken up. The other thing that's important is an officer takes every action possible to avoid force. Well, at that point, Senator West brought up, and I thought it was a good example, you know, the officer has to run through the whole checklist in their mind. And Senator West, if you recall, in one of the horrible school shooting cases, one of the officers remained outside and was severely criticized for that. So I certainly think we might need to do some things there. As far as number 2, turnover issues of dishonesty, you know, in this, when anywhere do we turn over mere allegations? At a minimum, this bill should be changed that it has to be a sustained finding, that the findings must have been sustained at a trial board. Mere allegations mean a defendant who's on trial, who has that detective as a witness against them, could be the person who makes the allegation, and then his lawyer could use it in court and it would be made public. No-knock warrants are very important for the safety of officers and the preservation of evidence. Remember, currently under the law, the officer has to put in probable cause why they want the no-knock, and a judge has to approve that. If you would like to put in more protections, we can have The officer has to swear it's needed. The state's attorney's office may have to sign off on it, on why it's needed. A judge would have to approve it, and the language in the warrant could be in large fonts so it's prominently displayed so everybody knew exactly what was being done. The duty to intervene for training, I agree, yes. To intervene, I agree, yes. But making it a crime, where do we do that to anyone else in the law? Maybe it could be a disciplinary action, but making it a crime goes way too far. Number 5, police must report certain crimes. I agree with the entire list, except making it a crime to not tell about excessive force. I think that one can be a disciplinary action, and that is 3 minutes and 39 seconds.
Gotcha. Gave you some leeway. I appreciate that. Okay, so now that's the end of the panel. So now we have an opportunity for Q&A from the members of the committee. So I see Senator Hedelman has a question. So Senator Hedelman.
I do. Thank you very much, Mr. Chairman. I wonder if I could ask Chrissy Roth from Amnesty International a question. You mentioned that Maryland is in a minority of states that does not have a use of force statute. And seems to me that you have a lot of experience in seeing what's out there and knowing about what the best use of force statute looks like. Could you direct us to what you think are potential models for us to pattern ourselves after?
Thank you so much for the question. Yes, that's correct. Maryland is one of 9 states without a use of force statute, which is among the Delmarva Peninsula, where I grew up, and Virginia, certainly. I would say there's still a lot of work to be done amongst all states in the US. Certainly none of them meet the international standards that we look for with Amnesty International. That is, those that are outlined through the basic principles of use of force of firearms. And among them, I think what's key to focus on, and certainly why you've seen some of my colleagues request necessity, is that particular element isn't well understood or underscored in any state statute. I think the best example to point to certainly is California. Over 2 years, they passed a bill that became law this year, but in 2019, they passed a bill after Stephon Clark was shot and killed in his grandmother's backyard while unarmed. And that bill is AB 392. It has that use of force should be used only when necessary. It also has an important provision that looks differently at the totality of the circumstances, as it's outlined in Graham versus Connor, which I spoke to earlier, as sort of foundational to use of force and our understanding of it. In their understanding of totality of the circumstances, or rather in Graham, it is limited to the moment that force is used. However, in the way that the law is written in California in AB 392, it also examines the moments or the events leading up to the use of force in consideration of the actions of the officer, as well as the subject. And just to second that sort of point and some of the other elements we hope to include that we believe are meaningful, in Delaware and Tennessee, they have in their statutes elements that reasonable options should be exhausted before force is used. And so I saw there were some committee members that felt challenged by the element, but other states do have that in their statutes. And as one of my fellow panelists admitted today, you know, the George Floyd Justice and Policing Act also includes one of those sections is the Peace Act, which includes a lot of the things that the committee is working, or my colleagues and I are working to do in creating what statutory limits are appropriate for use of force, really underscoring that it be reserved to limited amounts when necessary.
Thank you.
Thank you. And then I see we have a question from Senator Sidnor, and then we'll move on to Senator West.
Thank you, Mr. Chair. This question is also for Ms. Roth, specifically about use of force, but generally just in general, there have been a number of statements about things that are it being more important to be noted as policy versus state law. Would you mind kind of talking about the difference between categorizing use of force as a policy versus a state law?
Thank you for the question, Senator. Sure. Just in brief, I think it's clear that a lot of states have all police departments have use of force policies, and they vary in range, of course, and that's frankly not my expertise to know all of the intricacies of them, but there are many on the panel who are much more familiar with them than me. Though the important distinction to understand is that a use of force policy is only enforceable traditionally at the discretion of the top brass of that department. And while we certainly hope that officers who violate these policies are disciplined appropriately, we don't know we don't believe that may carry significant means of accountability. And that's why we call for the state to implement a statute or enact a statute rather. I think there are some clear examples where officers in sort of high profile cases acted outside of the policy and they remained on the force. For example, in Eric Garner's case where a chokehold was used in that particular policy. And so we just really express strongly that the state should really, or this legislature, seek to enact a law to provide for accountability as opposed to exclusively just a policy. I know in some of the earlier meetings of the law enforcement working group, there was a bit of a question about what is the status of things with Maryland, and just to underscore here that in fact Maryland does not have statutory limitations to the use of force, but the departments do have their own individual policies.
Thank you.
All right, thank you, Senator Sidnor. Next, we have Senator West.
Thank you, Mr. Chairman. I'd say I have two questions. First, Mr. Schellenberger, going back to bill number 1, it really seems to me it has 2 sections. The first section sets up a civil cause of action, and for which monetary damages would be the remedy. But then the end of the bill, which is on page 6, sets up a criminal case for felony assault for a law enforcement officer who intentionally causes physical injury to another using force that exceeds the amount of force appropriate under the totality of the circumstances. Now, these incidents of force frequently are momentary, instantaneous decisions, aren't they? Split-second decisions.
That is correct. Very typically, it'll be a situation where an officer will be confronted rather quickly with a situation and have to make a really quick decision. And as the other officers on the webcast will tell you, that's what they spend a lot of the time training in the academy, is how to make those decisions quickly, but also in a logical way. All I have to do is remind you of last week when we all saw 2 police officers in another state shot while they were sitting in their patrol vehicles. I mean, that was an ambush. And if they were going to use force, they would have to make a split-second decision and then, have to go through all of this. So to make that criminal really is pretty remarkable, particularly if we set a standard in the civil law that would give someone a remedy.
I went through use of force training in Baltimore County just over a week ago. I spent 3 hours out there, and part of it was putting me in front of this large screen with videos on the screen and a gun in front of me on a table. And I had to make split-second decisions whether I picked up that gun and, for example, in one case, shot a man in the back. I will say I would not have made the grade as a police officer. But
so I would encourage anybody who's involved in this type of legislation, I'd be willing to have you out to our training academy so that you could experience what Senator West did. I talked to my police chief, Melissa Hyatt, about this, and she invited a number of our folks out. Some of our council people went. I think it's a great opportunity to see what officers face every day.
And I just note that the people who are going to make the decision about whether the officer in such a case was guilty or not are 12 jurors, none of whom probably have experienced use of force training.
Correct.
Don't know what it's about.
Correct.
Okay. Secondly, Mr. Rose, let me ask you a question. I'm looking at bill number 6, which is the surplus military equipment. And during the course of the testimony, I paid more attention to that. One of the items there which is prohibited are drones. It would strike me that if the culprit or culprits got away, it would be helpful to be able to send a drone up over a nearby woods to see if you couldn't see them from above down in the woods, or if they're in a vehicle, have the drone hover over a vehicle as it's going along so you know exactly where the vehicle's headed. Is there any reason in your view why we should ban the use of drones by police organizations?
I don't know which type of equipment that the department or the county looks to buy, but I do think that if a department has an opportunity to buy equipment, it should be up to them to justify it to their local jurisdiction and their county council to be able to purchase it and show a need for it. But in looking at the list, when you talk about aircraft, there's an opportunity for a department to buy a helicopter or an airplane. When you talk about drones, drones can be used to search areas such as the Susquehanna State Park or the Gunpowder State Park to do surveillance from a distance or follow a car in a chase in case you want to break off the chase to make it more safer for the officers and the civilians involved. So when I look at this and you talk about vehicles, you're taking out cars and you're taking out vehicles you see a lot of times on higher stress scenes. It says destructive device, but I'm not really sure what a destructive device is in this bill because it's not defined at all. A destructive device could be a bat if you have a window. And then you have firearm, silencer, or grenade launcher. And somebody talked about it earlier. A grenade launcher can be used, fire tear gas, smoke, so that you can, cloud your advance or disguise your retreat. So, just that the way it's written is very unclear, and it looks like it just flat out puts a ban on these items when you can look at them and actually see different uses they might be able to have. But I do think having a state law that bans this would kind of take the power away from the local jurisdiction, because that county or city, if the police chief thinks he or she needs a piece of equipment and has an opportunity to purchase it, they have to then try to convince their local city or county council whether they need the funding. They need it enough to get the funding given to them to go and make the purchase. So that's where I would stand on those issues.
Can I just interject real quick? Just to be clear, it says, it's very clear that it says weaponized drones. And so, even being in the military, I'm familiar with, drones and weaponized drones. I don't think we need a Predator drone flying over Montgomery County. Sorry about that one. But then also there is a definition of a destructive device, and there's an article, in the bill, it actually cites the section, and then the definition reads, destructive device and firearm silencer pursuant to, but then.
I saw it referred to the statute, but I didn't know what it said. So.
Yeah, got it. It's in there though. So I would just say, just check it out. There's a clear definition of destructive device. But I think we have Senator Carter has a question, and then we'll move over to Senator Lee has a question.
Thank you, Mr. Chair. My question is for Commissioner Harrison and Mr. Rose, because it involves two different sets of data that you may have information about. Both of you, well, no, not you, Commissioner Harrison, but you, Mr. Rose, complained about the concept of creating a database disclosing information where there may be mere allegations. But I know that with respect to Baltimore City Police Department, when I was overseeing the Civilian Review Board, I was aware that less than 5% of allegations ever resulted in a finding of misconduct within Baltimore Police Department. I'm not sure about across the state of Maryland what those kinds of numbers are, the numbers of actual complaints versus the number that are actually where misconduct is found, and then there's actual discipline. I do know that less than 5% of officers that have ever been accused of anything criminally have been actually convicted. Something that number came up in some prior meetings that I was privy to. But my question to you is, if you do not agree with the disclosure of allegations, then what process do you recommend to be able to increase those numbers? Because we're talking about the internal system of investigation and discipline that results in this massive number of lack of finding of misconduct that has been a colossal failure. It simply doesn't work. Internal affairs investigating and policing themselves. And so the question is one with Baltimore Police Department and then police across Maryland, do you know the number of complaints versus the number of that are result in findings of misconduct and there's actual discipline enacted? And then number two is, if you disagree with the concept of disclosing the allegations, then what do you recommend to remedy the colossal failure of internal affairs being able to effectively investigate?
Well, I think you're referring to Baltimore City. I'm Baltimore County, so I can't give you any information on Baltimore City.
That's why I asked you both. So
you're asking me about which one?
your jurisdiction.
Well, your categorization of internal affairs being a colossal failure, I take issue with. I think the men and women that we have in internal affairs are chosen by the chief of police. They're chosen by a reason. They're very competent. I've been here for 33 years. I've both been on the side of being the one investigated and interrogated, and I've been on the other side doing the investigation and interrogation. And I can tell you the people in those positions take their job seriously. So when you talk about a colossal failure, the facts are the facts. The investigation leads where the investigation leads. An impartial investigator does not set out to prove a theory the investigator may have. The investigator gathers facts, asks questions, follows the leads, and comes to a conclusion based upon the facts. We do get a lot of complaints in Baltimore County. They have gone down seriously from 128 10 years ago to 50 last year. So that's 50 citizen complaints that came through internal affairs in reference to our members on 750,000 calls. So our members actually have, over the last decade, the officer to officer complaints are actually 63% of the internal affairs complaints, because there is no blue wall of silence here, at least in Baltimore County. Our officers don't have a problem making complaints against each other. We have a duty to report. It's in our policy, and we do it. In 2019, we had 79 complaints within the police department, officer to officer, and we only had 50 from the civilians. So you look at the numbers there, and you actually had 25 more complaints officer to officer than you actually had from civilians on 750,000 calls for service. So I do have a problem with an allegation simply being made public, because that allegation leads to some of the statements that I heard here today. That officer had 12 complaints. That officer had 15 complaints. Anybody can make a complaint. We get false complaints that are investigated and proved to be unfounded and exonerated many times. Those complaints were deemed to have been false. Some are deemed to where the officer did it and it's sustained. But you can't have a system where it's rigged to stack complaints that an officer may have a dozen complaints and 11 of them are not sustained or exonerated or unfounded. And the one sustained complaint is there, but then everybody talks about 12 complaints made against the officer.
You know the numbers, you said there are only 50 complaints. You seem to want to exclude officer to officer as if bad conduct between officers is okay. But my question was, like, of it's a small number, I agree, from what you used to have. Of the 50 complaints, how many of those actually resulted in a finding of misconduct and then discipline?
I'd have to get that information from internal affairs, but I think that traditionally it's around 10 or 11%.
Thank you. Commissioner Harrison? Yeah. Okay. Oh, sorry, go ahead.
No, I was going to relate back. I was going to ask you to refer back to your first statement, but you can go on.
So, Senator, I'm working to get the answer of the percentage of complaints that end in either sustained or some level of discipline as we speak. But I think we have made great progress in reforming our Public Integrity Bureau, formerly known as Internal Affairs. Though we're not where we want to be yet, we have new leadership, and I've actually hired a former special agent in charge who's actually the chief of public integrity for the entire FBI, who retired and took the lead as my deputy commissioner of public integrity, who we have now made investments in staffing, investments in training, and we have reduced the amount of complaints that have come in and improved the performance by improving the skill set of the individuals there. Now, like I said, we're not where we want to be. We are working to make those improvements every single day. With regard to the question of what complaints should be released, we advocate as chiefs and sheriffs that they should be the sustained complaints. But to your question to Mr. Rose, there are not sustained complaints that I believe qualify for that, like allegations where crimes have been committed, where officers have either theft complaints, perjury complaints, fraud complaints, sexual assaults, any other uses of force that would end in death or serious bodily injury. So it's the sustained complaints coupled with a qualified number of not sustained complaints. We believe exonerated and unfounded should not be released, because on occasion, some of them, or sometimes many of them, have been frivolous complaints. Not all of them, but certainly some of them. We wouldn't want those to be released, but certainly the sustained ones and the not sustained with the qualified number that I just told you. So there's some criteria that our working group has produced that we can get you pretty quickly that shows you which not sustained complaints would go with the sustained complaints. So, and then I think it's 32% of all allegations ended in a sustained finding for 2019. So far, it's at 18% this year. The rest are either not sustained, unfounded, or exonerated.
Thank you, Commissioner Harrison. Do you have any idea about what percentage of the complaints in the entire universe of complaints that you would categorize as frivolous complaints?
I do not. I do not.
Thank you. It would be a small number?
I would be speculating, and I'm sure an attorney would challenge me on that, an objection if we were in court.
Thank you.
Yeah. All right. Seeing no more questions for Senator Carter, I think we're going to move over to Senator Lee.
Thank you, Mr. Chairman, and thank you, panelists, too, for your excellent presentations, all of you. This is a question for Dr. Ray and Commissioner Harrison. This is respect to Senator Signor's bill dealing with the issue of the misconduct database, and I think Senator Carter actually had some of my questions asked, but I know that we all want to have law enforcement that protects our communities, our families, our individuals, and also is a community that will help law enforcement solve crimes. So we want to get the best law enforcement possible. And I see that this bill is a way to find out, the history of those that perhaps the commissioner, in your case, the people you'd want to hire to be the best law enforcement. So with respect to access, Dr. Ray, in other jurisdictions, have they had database collection similar to this that has helped law enforcement be able to get the best law enforcement officers possible to help solve crimes and keep communities safe? And I guess instill kind of that trust and cooperation between the different communities. And Commissioner Harrison, do you support Senator Signor's bill, or did you want to work with us on some of the details with respect? Because I noticed in the bill there's something that has to deal with reporting the outcome of each case too. Is that something you would support too? Go ahead, Dr. Ray, why don't you go first?
Senator Lee, thank you for the question. So yes, I think so, and it's starting to mount. I mean, on one hand, it's at the federal level that this is about to speed up, not only with Trump's executive order, but also with the George Floyd Justice and Policing Act. So at the federal level, this is something that's about to have a lot of traction as it gets rolled out, and I've been involved in that. On the state level, I think one of the best examples is Arizona, where they have essentially two different lists that the state of Maryland might be interested in that seem to kind of merge what people are saying. On one hand, it's a list that has everyone that's been found liable of misconduct or who have resigned while under investigation for misconduct, which, as people know here, many people know, that is something that happens quite often. And then secondly, there's just a public list that does not have police officers' names on it. but it does have the misconduct complaints that is made publicly available. And there's some context here because I've been working with the state of Arizona, so I know this. In short, if you look at Arizona compared to other states, Arizona has had some of the largest increases when it comes to officer-involved shootings. They were trying to figure out what was going on there. And what they found was that correspondingly, that complaints about use of force and other just general complaints against officers were also increasing. So part of what I know from studying policing is that oftentimes use of force and even officer-involved shootings and unfortunately killings, either by a police officer being hurt or a civilian being hurt, oftentimes there are downstream incidents that happen. And so those databases help with that. Nashville, Tennessee is also another example. They have a community oversight board that is part of the city of Nashville, that is funded by the city of Nashville. And they also have a similar database that they provide publicly available to citizens of the city. But again, that database that has all of the complaints doesn't have officers attached to it. It does have the list for transparency purposes. Then there's an additional list that has officers that have been found liable for misconduct.
So Senator, were you asking me about the JPR2 credibility as witnesses in misconduct database?
Yes, that's the bill.
And so, yeah, we do support that, but wanted to offer some additional language. And I think, some of that's already listed in there, like the state's attorney is required to transmit records related to the credibility. Officers who have been alleged to have committed acts which bear on credibility, integrity, honesty, and other characteristics that would constitute exculpatory impeachment evidence. There are some other pieces of language we wanted added into it, but conceptually we do support it.
Thank you.
Okay, do I have Mr. Neske? Would you wanted to chime in here? Is that right?
Yes, sir. Thank you. To Senator Lee's point about hiring the best and making sure that we are hiring good officers and not getting someone else's discards, to put it bluntly. MPTCS has a form, a personnel action form that any officer in the state of Maryland, if they're discharged or they resign, we have to send that form into them. And there are certain boxes that we can check. And even if they do resign, say in lieu of an investigation, that does trigger a flagging process so that when the officer is put forth for certification from another agency, they have that flag. They have to ask for a waiver in front of the training commission. And the training commission will then get the facts of the resignation, the facts of the investigation, and decide if that officer warrants recertification. Now, hopefully on the federal side, they're going to, if they move something forward, that will cover officers coming from other jurisdictions. But again, one of it is, it's incumbent upon the certifying agency to do their due diligence and doing complete backgrounds and making sure that we are digging deep enough and going down enough layers to find out if there's been a pattern of issues, especially out of state where the transfer records and the flagging data may not be so readily available. But yes, there are mechanisms in place that we can certainly improve. And I think a database to this point would strongly increase the information that's shared across the state and hopefully across state lines to make sure that these bad apples don't find employment elsewhere.
All right, thank you, Chief. Looking, I think I see Senator Sidnor's got another question. Go for it.
Thank you. And so there have been a number of statements that have been made about people filing false reports and not wanting to impugn the integrity of police officers, but false arrests are made by people, and so I wanted to ask this question to Ms. Levy with regards to sustained cases and the like. Do do sustained cases always remain sustained? Do they stay that way? I mean, do officers have the ability to plea bargain? Would you mind talking to that?
Sure, absolutely. Well, two points that I'm gleaning from that question. Number one, officers are concerned about their integrity being impugned. Certainly, we all know that the general public can walk into a commissioner's office and file charges against anybody, and that person could then be arrested. And there should be no greater protection for a citizen who's a police officer. If they haven't done it, like we tell people, then they can prove that out. They are entitled to due process in their trial board. But even more concerning than that is this notion that every sustained complaint, well, two things. Number one, in the consent decree, the Department of Justice found that complaints are not always adequately investigated. There was just a reported opinion from the Court of Appeals that said the Baltimore Police Department took too long to investigate those complaints, and 15 officers' findings were removed from their record. And so there has to be this level of transparency. I once litigated a case against an officer who had 15 complaints related to dishonesty. All of those were closed because the complaining witness didn't follow through, and nobody tried to reach those complaining witnesses. We don't want public policies that motivate officers to close complaints without findings. But lastly, and most importantly, we recently litigated a case where an officer was found fact sustained for perjury after a full investigation. And would you know, and the people in Maryland probably don't know, that police officers across the state plea bargain their way to other findings that are more palatable to themselves. In other words, they'd say, I'll take the general misconduct if you get rid of the perjury. And then an officer, that same homicide detective, is allowed to proliferate for years and years and years with nobody finding they were fact sustained for perjury. So when the FOP representative says that complaints are good and complaints are great and they're investigated perfectly and there's not full disclosure. And what happens to the cases where we hide fact sustained findings for perjury or plea bargain them away out of their record? And let's not forget that officers, at least in Baltimore, have been able to expunge fact-sustained findings without any due process proceeding or any adversarial proceeding whatsoever, because the FOP and the police commissioner, prior to Commissioner Harrison, made an agreement, and the legal department sanctioned it, that scores of cases could go from fact-sustained to then administratively closed without any proceeding whatsoever, which paved the gateway to expunge them. We had a full hearing and sent it entirely to the consent decree team last year. Fact-sustained findings are not being upheld regularly. And unless there is integrity in that process, then it should be transparent and public, and let the officer take the stand and say to his child, for Senator Reedy, who was concerned about that, you know, this is a free country where people have freedom of speech, and sometimes people say things that aren't true. And let's teach our children that everybody has the right to speak their piece and their mind. And that person can rest assured, if their father or mother is upstanding and didn't do it, that the truth will be known.
Thank you.
Thank you for that. And since we've kind of ventured in the conversation of the database, we have to first talk about the MPIA piece, which is access to those records. So if Mr. Roca, I know, wanted to chime in on this, so just want to give him the floor for a moment.
Yeah, Deborah Levy, I think, just made the point extremely effectively. But what we're talking about now is not simply a database, but access to records regarding police investigations of police misconduct. And there's this pervasive air of unreality that I just think has to be addressed when Mr. Rose says all the investigations are great, or when a legislator says all the investigations are great. There is no way for any of us, and frankly, any legislator, to have an informed opinion about that subject, because the records at issue are, because of a decision of the State Court of Appeals, said to be personnel records that are categorically shielded from disclosure. And saying, trust us, everything is fine, is not a way to engender trust. If you want to engender trust in the internal investigations, then make the investigations public and show that they are being done thoroughly, fairly, and competently. That's how you actually engender trust in the results. Saying we're doing everything great is not the way to engender trust. And so when I hear Commissioner Harrison say that there's no such thing as accountability without transparency, I agree with that statement, but let's make that statement real.
All right. Now looking across the room, do I see any other questions from members? Seeing none. Okay, that concludes the expert panel portion. So if folks that have provided their testimony, if they could exit the room, you can still obviously watch from the YouTube link. But we're now going to let in members of the public and start their testimony, 2 minutes each, and we'll start off with Mayor Kate Stewart, and then we'll go off to Mr. Gibson. I see you over there, so we'll get you next. So Mayor Kate Stewart.
Great. Thank you very much. I'm glad to be here. The City of Tacoma Park has a full-service police department, and over the last few years, as we have looked to make changes, it has become clear that we face some roadblocks for meaningful change because of current state policy or lack thereof. First, I want to recognize that any discussion of police reform at this time needs to acknowledge the need for institutional and systemic changes to how we address public safety in our communities. We need to stop nibbling around the edges and make real change. We have the opportunity before us, and we need to make changes to centuries-old culture and the legal structure that upholds it. Second, I want to stress that what we need from state action is greater assistance with mental health services, addiction, and other public health and safety issues that do not need a police response. Third, we need greater transparency, accountability, and civilian oversight for our police departments. To meet these three goals, we support first, expanding or establishing additional mobile mental health crisis units. This would potentially reduce the number of mental health service calls for police officers. Second, limiting the use of force by law enforcement. Maryland is one of the few states that does not have a statutory limit on police officers' use of force. We need a uniform standard across our state on use of force, provide just accountability for excessive force, and begin to change the culture of how force is used. We need more time to analyze the details of JPR 1, and we will offer comments on that later. Third, transparent investigations into police misconduct. The Maryland Public Information Act currently blocks access to information about how police misconduct investigations are handled. This does not build trust with communities and lacks transparency and accountability. Fourth, repeal the Law Enforcement Officers' Bill of Rights. Constitutionally, officers are entitled to the same rights as other state and local government employees, including first, an opportunity to be heard, second, a right of appeal. The LEOBR grants law enforcement officers special due process rights that do not exist for anyone else. It mandates that officers can only be investigated by other officers, and it ties the hands of police chiefs, preventing them from swiftly disciplining their own officers. We need to repeal the LEOBR to allow immediate termination of officers for egregious action and then set up an appeal process for officers. We should not be restricted in our ability to fire officers who commit egregious acts and keep them on the payroll or as employees. At this time, we support JPR 15, which I know you'll hear on Thursday. Thank you for your time and for all the work you're doing on this.
Thank you, Mayor Stewart, the best mayor in all of Maryland. All right. I'm going to now switch over. We have the state's attorney from Howard County, Mr. Gibson.
Thank you very much. My name is Rich Gibson, attorney for Howard County. I believe the elimination, to testify today about JPR 3, the no-knock warrants. I believe the elimination of no-knock warrants increases the risk of harm to society. I understand the desire to take corrective action. However, the goal of any choice we make is that not just that we be timely, but the choice be timeless. In this instance, if no-knock warrants were to be eliminated in a knee-jerk response to chasing the moment, our communities would suffer. No-knock warrants are an important tool that, if used appropriately, promotes the safety of the officers, the individuals whose home is being searched, and the safety of the community. I fully support regulations and changes in the law that would provide greater oversight concerning when no-knocks are used, such as requiring state's attorneys to evaluate the no-knocks for reasonableness prior to being submitted to a judge. I'll use fentanyl and the opioid epidemic as an example. If the police did not have no-knock warrants as an option, They'd have to go to the door of a drug dealer, assuming they have a warrant in hand, knock on that door, announce themselves, and say that they're there to search the residence. What would happen next is that the toilet would flush, the contraband would be removed, and the person who was promoting and pushing drugs into our community would not be held accountable. They would then re-up their supply and then put those drugs, that poison, back out into the community. Anecdotally, due to an agreement that we have between Montgomery County and Howard County, I'm aware of every police-involved death in Montgomery County over the last year and 9 months. During that span of time, there has been one death which occurred during the execution of a no-knock warrant. That loss of life is tragic. However, during that same period of time, that one death pales in comparison to the 75 deaths that have occurred as a result of opioid overdoses in that same county. Reasonable reforms make sense, and we, myself, six attorneys, are willing to support those reforms, but eliminating no-knock warrants goes too far. I urge you to give it an unfavorable report, and thank you for your time.
Thank you, State's Attorney. Next, we'll move on to Councilmember Will Jawando from Montgomery County, and then after that, Ms. Tawanda Jones, you're on deck. So take it away, Councilmember Jawando.
Thank you, Senator Smith, and thank you to the committee for giving me the opportunity to testify in favor of many of the steps that you're seeking to take here in these set of bills over the next several days that will be necessary to reimagine public safety and policing in our state. There are a handful of these bills that I want to thank all the bill sponsors for. It's very thoughtful legislation and addresses what is a core and very uniquely American issue with the legacy of systemic racism and inequity in policing in this country. As many of you know, I'm a council member here in Montgomery County. I represent all 1.1 million plus residents. I've also worked, I'd like to say before it was cool, like many people on this call, on this issue of criminal justice reform as a civil rights lawyer and as a council member. We've passed several pieces of legislation here in Montgomery County related, most recently, a landmark use of force bill that did many things that you're discussing. Raising the standard for when deadly force can be used, only allowing it when it's absolutely necessary, so raising it from reasonable to necessary, as a last resort after alternatives have been utilized, such as creating time, space, and distance, calling for backup, and the like. We also dramatically limited, to the conversation that was just being had, the use of no-knock warrants, no longer allowing them to be used in drug cases, and other limitations in the association of the approval of them. I would say on that point, I think that is something that needs to be reviewed very carefully, and limiting or removing them altogether would be appropriate. They're not only dangerous for the public, they're also dangerous for officers in many cases. We also created a duty to intervene and to report when an officer witnesses a fellow officer committing a crime or using excessive force. And we protected that officer in case they intervene and it finds out after the fact it wasn't called for. We want them to err on the side of intervention. And so that's another thing that was included. We also banned neck and corduroyed restraints, banned shooting at moving vehicles, striking restrained individuals, using force against fleeing individuals. And we required written guidelines. Very importantly, this doesn't get a lot of attention, but regarding police interactions with vulnerable populations, such as pregnant women, people with disabilities, those who are dealing with mental health issues, and a clarification that the minimum standard of force should be used with those individuals, and that you should consult those communities when making decisions on what's the appropriate level of force. Obviously, policing and public safety has been at the front and center of our national and local discourse after the murder of George Floyd. The dehumanization that required woke up many people to this longstanding issue, and I'm glad we're at a moment in time now where we're looking at making systemic changes. We know we have issues here in Montgomery County. We have issues in the state. A recently commissioned report that I asked for on police data shows some really stark numbers that in some cases meet or exceed national averages. African-American Black residents make up about 19% of the population, but accounted for over 55% of those involved in use of force incidences here in Montgomery County, over half of the arrests in 2018. If you add Latino residents, you get over 75% of the people who had force used against them in an encounter are Black or Latino in this county, despite much lower populations. We also need to look at statewide transparency and accountability measures, which I know you'll be looking at in coming days. I'm glad that we were able to pass my first bill, the Law Enforcement Trusted Transparency Act, which creates independent police investigations and public reporting in the case of a police-involved death. I hope that that will be a statewide effort. I know that's one of the bills you're considering. Happy to partner with you and work with you on these issues. It's a very important time in our history. I think we have the time, the momentum, and the righteous wind at our back. So I want to commend again Senator Smith and all of your colleagues for pushing these reforms forward. Last thing I'll say is on Lee Ober, I know that's another day, but since I won't be able to come back and testify, you do need to review the Law Enforcement Officers Bill of Rights and make serious revisions, if not rescind altogether. I'm all for the collective bargaining rights of our police officers, but this law, as we know, is out of whack with common standards and provides, it actually serves as a deterrent for accountability and transparency to the public in very serious situations. So thank you, Senator Smith, and thank you to your colleagues, and I look forward to tracking this legislation as it moves forward.
Thank you, Councilmember Chawando, and thank you for all your work in the county. You've certainly served as a model and a template for the rest of the state. So thanks for the hard work and keep it up. All right, next we'll move on to Miss Jones, Tawanda Jones.
Hi, sorry about that. I had to unmute myself. But thank you, committee, for hearing me, and a special shout out to Senator Jill Carter. I'm in support of every last one of her bills from JPR 1 through 7. And I'll explain why. I am the sister of Tyrone West, who was brutally executed right here in Baltimore City on July 18, 2013. And I'm here in representation of all the victims of police brutality, not only in Baltimore City, but worldwide. It needs to stop. Number one, JPR 1, the law officers' use of force. They're not judge, jury, and executioner. They have no right to use that type of force, deadly force, to kill someone when you see that it's clearly not a training issue. It's rather if they want to kill somebody or not, and it needs to stop. Number two, JPR number 2, database. We need public access to all that, because I think about when my brother was murdered, we had no clue of Ruiz and Chapman's brutal history, and they were the first two. My brother was beat to death by 11 and 15 armed men and women. Okay, let's be crystal clear on that. So we had a database, whereas it was not locked up on the desk of Marilyn Mosby's office, whereas it was transparent for the whole public to see. We definitely need that. Number 3 is number 3, the no knock warrants. That is horribly disgusting to be able to go in someone's house. And even you think about with Breonna Taylor, and that's on a national level, but we have Breonna Taylor's right here in our own city, okay? To actually, even the ones that are not murdered and they had the wrong house, but just the ones that are left with that type of trauma. And I think about Mr. Green, who was another victim of Ruiz, the repeat violent offender. His house was broken into, the no-knock warrant several times by Officer Ruiz, and nothing was found, to the point this man had to leave Baltimore City. Shame. And number 4, the duty to intervene. Had any of those killer cops would have intervened and saving my brother's life, he would be here. And do you let somebody from, I'm David Lewis from Morgan State University, come sack and brutally murder one unarmed man? Tyrone West was Jewish food. Okay, let's be crystal clear. 18 minutes, brutal life, brutally beat, murdered. And then number 6, militarized equipment. I think about Corinne Gaines, brutally executed in her home with her baby. Shame. And number 7, whistleblower protection. I think about Sean Stewart, who knows what he would have said. Who knows, he was about to testify, killed by his own. We're not stupid. He was murdered by his own. And last but not least, Joe Crystal ran out of this city with rats on his car because he was a whistleblower. We need good officers. I feel bad for the very few good officers that put their life on the line and take their job seriously. I really feel sorry for them. Until you guys clean house, we're gonna constantly keep having it. And last but not least, when Schellenberger said about a split decision, they don't have a right to take our lives. And I think it was Mr. Dave who said, well, come along and ride with us to a training and things like that. No, you guys need to come along and be Black for a moment in our community where we're pulled over for a traffic stop and you're brutally murdered. I had a one thing that happened to me with a light bulb, and I had 6 armed men come to my car after my brother was murdered with guns drawn to my head about a light bulb. So it needs to stop. So I'm in definitely support, and we need to stop. We're more than hashtags and body bags. Thank you so much. Justice for Anthony Anderson and all the victims, Tyrone West, the list goes on. Free Keith Davis Jr. Thank you guys so much.
Thank you, Ms. Jones, for hanging in there with us, and thank you for your passionate testimony. Thank you. So we'll now move on to Monisha Sheriel. Monisha here.
Thank you.
Hey, how are you?
Good, thank you. I appreciate the chance for the public to engage on this discussion of how to transform policing in Maryland so that it protects communities without endangering them. But the conversation is incomplete without a look at how we police our children in school and the unintended harm school policing has inflicted on our youngest residents, particularly Black children and children with disabilities. And I want to offer just some brief facts to start that conversation. In 2018-19, over 3,100 kids were arrested in Maryland public schools, generally by police officers called SROs, who patrol the halls in each district. 56% of the arrests targeted Black students, even though they're only about a third of the student population, and there are no differences in behavior across race. 30% of arrests target students with disabilities, often for nonviolent disability-related conduct. Students with disabilities are only 12% of the student population. And about 70% of these arrests were for fights not involving weapons and offenses like disruption, disrespect, trespassing, smoking. Most of the remainder are for drug possession, something as simple as marijuana in a backpack. And some of these arrests have involved significant force, adults holding down children, sometimes young children, resulting in significant injury. So we're arresting kids for having disabilities. We're arresting kids on the basis of our implicit and our explicit biases. We're arresting kids for being kids in the place where they're supposed to learn how to become successful adults. This traumatizes children, pushes them into the criminal system, and derails their education. Regular police presence is in this way making schools less safe. These safety harms are not balanced by any safety benefit. Studies show definitively that officers stationed in schools have not stopped school shootings or decreased any kind of school violence at all. By contrast, when you build relationships among students and staff, you make it easier to resolve conflict peacefully. When you provide students who have suffered trauma with mental health care, you bring them out of fight or flight mode so they don't lash out when provoked. Maryland's 2021 police reforms must include legislation to reimagine school safety. We need to get cops out of our schools and to redirect the $10 million per year in state spending on top of substantial local revenues away from SROs and towards school mental health, wraparound services, and restorative approaches. Thank you for your consideration and your time today.
Thank you very much for your testimony. So, next we'll go to Tracy Shand. Is Tracy here? All right.
Yes, I'm here.
Oh, there you go. How are you?
Yeah. How you doing today? My name is Tracy Shand. I am Leonard Shand's sister. My brother was stabbed by Officer Whiting in New Carrollton on May 4, 2018, and then killed by 10 officers a year later in Hyattsville, Maryland on September 26, 2019. These officers failed to call the medical unit. They used an illegal flashbang and shot my brother over 44 4 times, killing him. These officers were placed on, were back on duty while there was still an investigation going on, and there was no consequences. They were not indicted, not even the officer that shot the illegal flashbang, not even the officer that shot the beanbag, not even both officers that shot the illegal flashbang and the beanbag together, discombobulating their other officers to make them not be able to function. And they all fired off on my brother, killing him with over 44 shots. Maryland must enact legislation to defend and limit circumstances under which law enforcement can use deadly force. And you probably already know other states have laws limiting police use of force. Maryland does not. The other states recognize the benefits of providing police with clear guidelines on when to use deadly force. They have taken proactive steps to prevent police shootings and the public backlash in many cases. Maryland should do the same. We do need this policy or something done with these officers. There was an officer on here that I heard say, well, we're doing our best and we have the best training. That's not true, because I know officers. I know quite a few of them. And I've witnessed officers telling me that they had to go outside of the police department, police academy, to get special training on how to defend the citizens in their state. So I've interviewed police officers in different states: Ohio, Connecticut, New York, DC, Maryland. And I'm telling you, Maryland is not in a good standing point at this moment. You need to either find a way to train your officers adequately to where they can actually defend the citizens, or you're going to get a backlash, because citizens are going to start uniting and having to defend themselves from the officers instead of the officers defending them. So you got to pick a side. You got to pick which way you want to go with this. Either you want to protect the citizens and we all live peacefully, or you want to continue to condone these type of acts with excessive use of force. People getting killed, over 44 shots. What, the first 2 shots didn't count? So you had to keep going? It does not matter what the situation is. That is excessive. So I need for you to consider this and make the right recommendation, because we are all talking in the community, and a lot that's what's been said today, a lot of things I can sit back and say, okay, I can understand that, and I can agree. And there are other things when other people spoke that I'm like, no, you need to go have several seats where we totally are listening to you, because we are clear on what your agenda is. Thank you very much for your time, Chairman Smith, and I appreciate everyone listening to me today. Thank you.
Thank you, Ms. Shan, for your testimony, and thanks for hanging in there with us. I know that I'm sorry to hear about the loss of your brother. Obviously, I'm familiar with your story, and I know that it's not easy to talk about it every time. So thank you for offering your perspective and being here today. So thank you.
You're welcome. Thank you.
Thank you. We'll next move on to William Millian. Sir, the floor is yours.
Thank you, Mr. Chair. My name is Will Meyer.
I'm sorry to hear about the loss of your brother. Obviously, I'm familiar with your story, and I know that
on behalf of the Fraternal Order of Police, Maryland State Lodge, and I want to start by commending this committee for having the Fraternal Order of Police a part of this important discussion on police at a time when legislators from around the country, some in our own state, are blindly calling for the defunding of law enforcement agencies and the repeal of basic due process protections afforded to law enforcement officers. This committee is engaging with citizens and law enforcement to develop a strategy that works for all Marylanders. While some legislators are more interested in disparaging the work of the members of my profession and the profession itself, this group has a chance to be a standard bearer for what reimagining policing could look like. While defund the police might be a trendy phrase intended to score political points, for those of us who have dedicated or sacrificed our lives in service to others, it is a sad reflection of misguided innuendo from folks without a real plan for change. The work of this committee is important, and I urge you to pursue your mandate in a thoughtful manner. Consider the ramifications of repealing or retracting basic laws that afford police officers due process. Consider similar measures that have recently occurred around the country and the collateral effects of those actions. And then consider the fact that law enforcement morale is low. Recruitment and retention ratings are plummeting, and crime is skyrocketing in places where legislatures have quickly passed thoughtless police reforms. And then consider the years of work, the many years of work, in which Maryland's law enforcement community has engaged to help strengthen the relations within our communities. This is not and should not be an us versus them conversation. We want to serve and protect our communities, and we are interested in practical solutions to help us reach that end. Thank you.
Thank you for your testimony. I assure you everyone from the ACLU to the FLP will be at the table as we proceed, and everyone in between, and most importantly, the community members that we're hearing a little bit from today. Okay, next we have the Reverend Mr. Yeary. How are you, sir?
Chairman Smith, good afternoon. Vice Chair Wallstriker and members of the committee. I will do a quick flyover, and certainly I share some of the sentiments of Mr. Milam in that we all agree that we want healthy police-community relations. Let me just kind of give you some take in my role. First, I pastor in Baltimore City, pastor of Douglas Memorial Community Church. I'm also the Chief of Global Policy of the Rainbow Push Coalition, which is the international human and civil rights organization founded by Reverend Jesse Jackson. So in that capacity, I'll kind of give you two assessments going JPR 1 through 7, just very quickly, about how to strengthen as a starting point these important proposals. Under JPR 1, the prohibition not applying to use of force in a manner consistent with the program of training in the last paragraph, I would think there needs to be some assessment, periodic review of the training to make sure that the training that is used as an exception meets with the standards that are amongst the best practices at the time. So there's some currency concerns there. Under the credibility as witnesses, if the police training commission is going to be kind of the keeper of that process, they are appointed, they are not elected. I think there needs to be some concurrent jurisdiction, particularly when it comes to credibility as witnesses, assuming that that inference includes the potential of perjury or assumptions of perjury before a tribunal. We would want to make sure that we've got some accountability by someone who has been elected by the people and not just appointed by the consent of the Senate. Under JPR 3, when we get to the no-knock warrant, I disagree with State's Attorney Gibson. I am on the way to Louisville actually tonight. I've been back and forth to Louisville 6 or 7 times. The city is already under a state of emergency in anticipation of the Attorney General's ruling today on what's going to happen with the police officers in the Breonna Taylor killing. I would just suggest that rather than this being a regular bill in the course of order, it should be an emergency bill simply because no-knock warrants are a hazard to the community, and we don't want to wait until October 2021 to get some change. JPR 4, I would just say the criminal penalty, depending on the level of harm and injury, if the force used results in serious injury or death, I would suggest that the penalty be raised accordingly in consideration whether or not that should be a felony as opposed to a misdemeanor. Under JPR 5, under the summary, the duty to report is good. But it does not clarify the duty to investigate by the chief and any further reporting requirements. I think that needs to be fleshed out. Under your bill, Mr. Chair, I appreciate the surplus military equipment. I think some clarification on crowd dispersals and chemical agents needs to be kind of spelled out. We're seeing that across the country in terms of the use of tear gas and the like. We would want to address that. And then finally, under JPR 7, I think that bill is for me. The whistleblower protections are important. If it's going to have deterrent effect, I think the damages amount needs to be raised. Otherwise, we begin to start running cost-benefit analysis. Can we absorb $5,000 in damages to intimidate witnesses? I'm looking forward to a very robust conversation. I may see you tomorrow and Thursday, albeit from Louisville, but I thank you for the opportunity to share, and I'm looking forward to working with you this session.
Thank you, Reverend, for your work here in Maryland and across the nation. This was good. Thank you very much for that.
Thank you.
Okay, next we'll have Ms. Parker, Janet Parker.
Hi, my name is Jenna Parker. I am from the 25th District of Maryland, from gorgeous Prince George's. I'm here to discuss several things that I feel like are important in reimagining police. Reverend Yearly kind of said things, so I'm not going to rehash what he said because I feel like he eloquently expressed it. I will say in relation to policing, there should be a dictated, specific, detailed use of force standards. This sets a very high bar for our police officers as well as protects them and the public. I think a lot of times when we have conversations about reimagining police and putting specific standards in, there is this thought process that it's a us versus them, when the thought process should be these standards are to protect the police officers as well. In relation to a misconduct database, I think it's important in relation to transparency for the community to know who is policing them and the things that have come up in relation to their interactions with the public. It is a disservice to the public and to the community not to know which officers have had issues of misconduct with the public. Limitation or elimination of no-knock warrants. It was said earlier, implied by a state's attorney, that essentially people are not to get due process, that when they are labeled because of probable cause to enter their home, they are therefore subsequently automatically guilty, and therefore they should be, whatever happens, happen due to a no-knock warrant. No-knock warrants have a horrible impact on the community. They put the community at danger. They also put officers at danger, and the use of them and the implication that was stated earlier kind of takes away from the Constitution, not just of Maryland, but of the United States. A duty to intervene, police officers, as a former educator, we were mandated reporters. If something happened to a student that we knew of, we had to report these incidences. And I don't, as a former educator, I never held someone's life, quote unquote, in my hands. I didn't carry a weapon or stun guns or things that could hurt children. So it should be almost just, yes, common sense that another officer should intervene when they see an officer using excessive force. Also, duty to report misconduct. It shouldn't just be, I see this, I've intervened. You should also report it. And yes, it should be fleshed out of what happens once it is reported. And local agencies should not be getting military equipment to police their communities. It's just not appropriate. Additionally, in relation to defund the police, we can use a different term. We can use reallocate, if that makes people feel better. But defunding the police is not about harming the police establishment in relation to the ideals that they are trying to accomplish. It's about acknowledging that most police are called into situations because there are a lack of resources within communities. And if you take the money that is being utilized for this police force and put into resources within those communities, there is less need for the police and therefore subsequently less need for these possibly violent interactions. So when people talk about these things about defunding police and try to make it seem like it's something that it's not, it's about reallocating resources to the community who needs it. And so that's my testimony. Thank you.
Thank you, Ms. Parker. Thank you for being with us today, and thanks for hanging in there. Next, we'll have Ms. Holly Latanya. And before you start, Ms. Holly, I just want to say that if folks have finished their testimony, if they could kind of jump out of the room, and then if you want to continue watching, watch on the YouTube link, just because we're going to be admitting folks kind of on a rolling basis. So once you finish, if you could wrap up and if you could just exit the meeting, that'd be great. So Ms. Holly, the floor is yours.
Thank you. Good afternoon, Chairman and members of the committee. My name is Latoya Holly. I'm here today as a representative of my brother, Anton Black, and our family to request that you repeal LEOBR, pass Anton's law, pass a use of force law, and amend NPIA. I will do, to the best of my skill and judgment, diligently and faithfully, without partiality or prejudice, execute the office of police officer. This is one of the last statements that is in the oath of office, which is taken by every law enforcement officer in the state of Maryland. Yet, this part of the oath is not always upheld, especially when involving a person of color. This is an alarming, disproportionate rate of unarmed Blacks being killed by Maryland police officers. My brother, Anton Black, was one of them. Anton was a young man who was a star athlete, model, actor, and soon-to-be first-time father who was murdered on September 18th, 2018 by law enforcement officers. It all started with an initial stop by Thomas Webster IV, an officer who had been previously tried for kicking an unarmed Black man in the face and breaking his jaw. During the investigation, it was learned that Webster had nearly 30 use of force complaints on his record. Yet he was able to continue to police without investigation and left the state of Delaware and policed the neighborhood in which my brother was killed, which happens to be Greensboro, Maryland. Essentially, Anton was arrested, tried, convicted, and executed in less than 30 minutes from his initial encounter with Webster, within 3 feet of the window to his bedroom, and less than 2 feet from our mother. Our request to place the officer on paid administrative leave were unanswered, allowing all officers involved to continue their duties as if Anton's killing was comparable to a simple traffic stop. To this day, most of the officers involved are still working in the capacity of law enforcement officers. Now we are in a climate that our technology is capturing the way Blacks are being policed and killed, not only in Maryland, but other states coast to coast. What has been a reality in the Black community for decades is now being captured in video and is viewed worldwide, eliciting protests from other countries, but continues to fall on deaf ears when it comes to reform. Do our lives and the lives of our sons and daughters, brothers and sisters mean so little? The system is broken and we need to fix it. Not only to provide justice to the victims and their families, we need to fix it now to save the children who are coming up after Anton Black, George Floyd, Breonna Taylor, Freddie Gray, Eric Garner, and the countless others who have fallen victim to those who have sworn to protect them without partiality or prejudice. And I did want to also just thank Senator Carter and Gabriel Acevedo, who have been working diligently on the reform. It's very near and dear and close to all of us here. And we appreciate the time that you're giving us to give our testimony and to hear our side of why this is so important to the community and to the families of the victims that have been involved in police killings. Thank you.
Thank you, Ms. Hawley, and thank you for your continued advocacy. It makes a big difference. And I know that Senator Carter and Delegate Acevedo have been hard at work. So we look forward to working with them going into the next session. So thanks for hanging in there with us, and thank you for being here today.
Thank you.
Okay, next we'll have Michelle Hall. Here we go.
Yes, I'm present. Thank you. Good afternoon. My name is Michelle Hall. I currently work as a juvenile public defender in Prince George's County, Maryland, and thank you, Chairman Smith, for allowing me to be here. As someone who was just stopped earlier today for driving while Black, I think it is essential that we have blunt conversations about how police misconduct, big and small, breaks down relationships between police and communities. But in the process of holding Maryland police accountable for their conduct, we cannot forget about the presence of armed police officers who have been rebranded as school resource officers in our public schools. These armed police officers work at the behest of police departments, yet are present in our schools through memorandums of understanding. There are many unknowns about who these officers are, how they are chosen to be placed in our schools. And the memorandums of understanding between school districts and police departments leave investigations of use of force to the police departments. And yet we have examples like the Prince George's County Police Department, where out of nearly 7,000 incidents of use of force, 99% were rubber stamped as justified, and use of force was disproportionately used against Black citizens, even in this majority Black county. We must be clear that armed police officers in our public schools come from the same departments that house the officers whose misconduct and use of force is at the center of these hearings. The result of armed police officers in our schools is the increased criminalization of typical adolescent behavior, particularly of Black children and children with disabilities. In my career as a juvenile public defender, I have represented kids in cases that I never would have dreamed would result in prosecution, and my colleagues would say the same. We have represented kids prosecuted for a school fist fight, for taking another kid's lunch money, for trespassing at school when there's no summer or after school programming. We have represented 11-year-olds charged with malicious destruction of property for coloring on a kid's jacket. We have represented kids charged with disturbing school activities for talking back in class. We have represented kids who have gone to an SRO for help with an issue at school only to be prosecuted based on that very same conversation. And we have represented kids who were in the midst of a mental health crisis and a poorly trained SRO escalated the situation and then charged that child with resisting arrest. The presence of armed police officers in our schools enables the funneling of children into the school to prison pipeline. And even when an arrest does not result in a court case, The reality we hear from our clients is that the presence of an armed, uniformed officer changes the learning setting and escalates simple disagreements, contributing to a culture of criminalization and antagonism in schools. Let me be clear. I hope to never, ever represent another child who is being prosecuted for something that happened at school. And any meaningful police accountability in Maryland and a reform bill package must include the removal of law enforcement from our schools. Thank you.
Thank you, Ms. Hall. Next, we'll go to Ms. Veith, Danielle Veith, and then we'll move to Mr. Montgomery, and then Ms. Willis, Greta Willis. So just that's the next three. Ms. Veith, former D20 resident, now you've absconded to District 18. So
Sorry.
We miss you, but
regret.
you.
Hi, good afternoon. My name is Danielle Veith. I'm the Volunteer Maryland chapter leader for Moms Demand Action, and here today on behalf of the hundreds of active volunteers and thousands of supporters across the state that work with us. We're committed to ending gun violence, and when 92% of people killed by police in Maryland are killed with guns, we know police violence is gun violence, and we can't end gun violence without police reform. When George Floyd called out for his mother, every mother heard him. We must fight the toxic combination of systemic racism, America's gun culture, and the militarization of law enforcement, because all of our children deserve to live in communities free of gun violence. Everytown for Gun Safety, the umbrella organization of Moms Demand Action, Students Demand Action, and the Everytown Survivor Network, advocates for a number of policies aimed at reducing police violence, including these principles. 1, strong standards regarding the use of force by police. 2, a focus on de-escalation tactics by police and rebuilding relationships with communities they serve. 3, early interventions to identify problem officers before they commit further acts of abuse. 4, independent investigations of use of force incidents that include strong civilian oversight. And 5, transparency around use of force policies and incidents of misconduct. During the upcoming session, Moms Demand Action supporters will advocate for legislation that furthers those goals. We stand in solidarity with the Coalition of Civil Rights and Community Groups, supporting the 5 pillars of impactful police reform, especially that use of any physical force by police should be limited to situations in which it is necessary to make an arrest. Deadly force should only be used to prevent an imminent threat of death or serious bodily harm. Officers should never use more force than is absolutely necessary and only when all other options have been exhausted. And armed law enforcement officers have no place in our children's schools. Together with our community partners, we will continue to call for a justice system that's fair for all of our children and ask our legislators to do everything in your power to combat police violence in our state. Thank you for your time and for leading on these conversations.
Thank you very much, and thanks for hanging in there with us today. So Mr. Montgomery, I had you in the queue next, but I skipped over someone. So Mr. Rhodes, James Rhodes, going to go right before you, and then we'll go into Mr. Montgomery and then to Ms. Greta Willis.
Good afternoon, committee members, Chairman Smith. Thank you for the opportunity to be here today. I'd like to thank you all for the time that you have placed into addressing a very, what I would consider urgent issue. I'm here on behalf of the Maryland Association for Justice, the Civil Rights Division, but I also like to state that I'm here as a multiple time victim of police misconduct personally. I'd like to address the issue of the duty to intervene, which is JPR 4, because I heard a number of persons speaking on the issues with respect to criminal prosecution. What's been missed here are the number of issues that make it actually more reasonable to have this legislation go forward than not. First, you have jurors that make decisions based on expert testimony. That expert testimony is brought to them in addition to a number of other pieces of evidence for any particular person, whether it be a civilian or an officer that's charged with offenses related to violating their duties. In order to get to that point, however, you have to discuss the fact that the people who have opposed this legislation are the very gatekeepers making decisions about whether or not officers would be charged in the first place. So the prosecutors who've sat here and discussed their opposition to JPR 4 are actually the ones making decisions as to whether those charges would go forward in the first place. In order for an officer to even at the point of a conviction, they have to get past, one, their own conduct, two, a prosecutor making a decision based on the evidence that's available, three, experts who determine whether the officer has or hasn't violated their duties, and four, a jury who has a jury and or a judge who has the duty of considering the prosecutor's position, the expert's position, body-worn camera footage, and eyewitness testimony. So when they talk about issues dealing with officers making split-second decisions, we're actually talking a little more about common sense differences. We're talking about the cases of the Baltimore City officer who followed a citizen out of a bar. The citizen crossed the street. The officer continued following that citizen while his partner stood by, watched the officer follow the citizen across the street. And when that first officer began pummeling the citizen in his face and his girlfriend simply stepped in, the second officer actually pulled the girlfriend away to allow the pummeling to continue. We're not talking about instances of police officers such as the one in California, the two who were shot, where no one is actually making a decision about whether or not they should have de-escalated prior to taking action. We're talking about common sense situations where there's been time for the secondary officer to perform as his duties require. So I think we should all concentrate on the fact that common sense issues don't dictate the outcomes or the situations that the prosecutors are talking about. And we should consider that as they stand here discussing their opposition, oftentimes more than not, they're the ones deciding that the charges wouldn't even be filed in the first place. So having gone through that with clients and also having been a citizen myself on multiple occasions where the first decision is for an officer to use force, and other officers where I've asked, hey, are you standing here and allowing this to happen? I can tell you that it's something that should be given considerable consideration. Thank you for your time.
Thanks. Thank you, Mr. Rhodes, and appreciate you sticking in there with us. So next, we'll go on to Mr. Montgomery.
There we are. Now I've unmuted myself. Thank you. I'm a resident of Senator Addie Eckert's district on the Eastern Shore. I'm a columnist and editor of the Chesapeake Observer. My opinions are based on my interviews of present and former law enforcement officers, my own research and reading. I've sent written testimony on several bills, but I'm just going to speak to number one today, the bill dealing with the use of force. It's my opinion that this bill will make effective policing impossible in Maryland. It sets numerous prerequisites for the use of force, and it puts the burden of proof on the police officer to justify any deviation. And then it imposes severe civil or criminal penalties if the standards aren't met. By the time an officer facing a threat remembers and complies with all these conditions, the attacker is likely to injure or kill someone. If she leaves out a step, then she could be convicted of felony assault. I suggest there are only two ways an officer can avoid these risks. She can remain in her squad car or she can run away. That's not what we want police to do. We see what happens when that is the case. Violent crimes and homicides skyrocket in precisely the minority districts that we all care about. The standard for use of force should remain whether it was reasonable. That's a standard which the courts have centuries of experience in applying. The threshold for criminal prosecution should be the same as it is in federal law, that he or she acted willfully to cause harm. Despite some highly publicized incidents, the fact is that police misconduct now only occurs in a very small percentage of interactions. And there are many ways to improve on that good record without the punitive provisions of JPR 1. Finally, I believe that police officers have a natural and moral right, as well as a duty, to defend their own and other innocent lives. Don't take that away. Instead, ask yourself, who would be willing to become a police officer with their hands tied in the way that this bill would do? Thank you very much.
All right, thank you, Mr. Montgomery, and thank you for your patience today. We'll now move on to Ms. Willis, Ms. Greta Willis.
Hi, good afternoon, greetings. My name is Greta Willis, the mother of Kevin L. Cooper, also a volunteer of Moms Demand Action, as well as the outreach director for Marylanders to Prevent Gun Violence. Let me explain to you today why I am here. On Saturday, August the 12th of 2006, my 14-year-old son was shot and killed by an inexperienced Baltimore City police officer with 1 year on the force. My son was experiencing a mental health crisis. I called the police for seeking help for my son. Instead of receiving help, my son, while holding a plastic dustpan, was maced and shot in my home in front of me as I was holding my 10-month-old granddaughter. There were 2 officers on the scene, and one officer left, stated the call was abated, meaning it was over. The other officer stayed and antagonized my son, then shot and killed him. Think, if the officer was in danger, why did his partner leave a rookie officer still on the scene? I was never given an opportunity to accompany my son to the hospital. I pleaded with the officers numerous of times to exit the premises. He chose to stay and escalate the situation as opposed to de-escalating. He became the judge, jury, and executioner of Kevin's life. There were no criminal charges placed against the officer. During the hearing, my family was offered $10,000 to settle the case, in which we refused. Kevin was a brother, a son, an uncle, and a friend. He had just completed his first summer employment with YouthWorks. My daughter was overseas fighting for our country, and someone who was paid to protect and serve the community was murdering her brother in his home. There is no police accountability in Baltimore City Police Department, even now. If you in this department would have investigated our case a little further, instead of covering up and declaring on the same day of a shooting which occurred at 9:30 a.m. a justifiable homicide, Kevin's life would have been spared. On the same day, how can you justify a homicide? Where is the investigation? It is too late for my son, but as a mother, a grandmother, I am crying out and representation for my only child, my grandchildren, and all sons and daughters across this nation. I urge you all to make police accountability your #1 priority so our children can live. Police violence is gun violence. Thank you for your time, and I urge this committee to vote and to make changes. We need police reform and accountability now. Thank you for your time.
Thank you, Ms. Willis, and thank you for sharing your story, and thank you for all that your family is continuing to do to advocate. So thank you very much for that. We'll next move on to Nancy Soring, and then Melissa Hopmeyer. Ms. Hopmeyer is after that. So Nancy, you're up.
Thank you. These remarks are on behalf of the League of Women Voters of Maryland. In June of 2020, the League of Women Voters of the United States issued this statement. Americans agree federal policing laws in our country must be changed. The issues with policing are not simply the result of bad apples. It is the result of systems and policies born from the legacy of racial discrimination and oppression, where Black people and people of color are treated as dangerous enemy combatants rather than human beings with equal rights under our Constitution. This problem cannot be trained away. Following that, the League of Women Voters of Maryland was proud to sign onto a list of 5 critical reforms endorsed by 89 organizations. This package of reforms represents the collective thinking of advocates who have been engaged in this work for many years, and more importantly, individuals whose lives and loved ones have been impacted dramatically by the deep flaws in our system of law enforcement. We do understand the sense of urgency that motivated Chairman Smith to call for this unprecedented bill hearing when the General Assembly is not in session. However, the League of Women Voters has long believed that democratic government depends upon informed and active participation of citizens. The League further believes that governmental bodies must protect the citizens' right to know by giving adequate notice of proposed actions, holding open meetings, and making public records accessible. We learned about this hearing on Wednesday, September 16th, via an email from Senator Smith's campaign. The announcement that the bill language would be available, and it said that the bill language would be available at 5 p.m. that evening. Then I learned that in order to testify, we needed to sign up by 9 a.m. the following morning. How could we possibly analyze such complex and critically important legislative proposals to determine the league's position in that time? Therefore, we've decided to oppose these bills. Although there might be some merit in each of them, this rushed process is unacceptable to our strong commitment to transparency in government actions. Since then, it has been clarified that this is just the first in a long procedure. So we look forward to future collaboration to address this important issue. I'm sorry, my testimony couldn't be so specific, more specific about the bills. Thank you.
Thank you, Ms. Soring. And again, I'm glad you pointed out that this is just the beginning. So we'll look forward to working with you in the months to come. So thank you very much for hanging in there with us. So now Ms. Hopmeyer.
Good afternoon, Mr. Chairman and members of the committee. My name is Melissa Hopmeyer, and I am the Chief of the Special Victims and Family Violence Unit, and also the Legislative Policy Chair for Prince George's County State's Attorney's Office. I am here to provide comment specifically on JPR 5, an officer's duty to report, which seeks to codify a criminal penalty for a police officer's failure to report specified crimes, including but not limited to use of force, theft, fraud, and sexual assault. As a prosecutor, and more importantly, as a citizen, I watched in horror the murder of George Floyd, and I understand in my office joins in the desire to hold responsible the officers who betray their oath of office here in Maryland and fail to act or report these types of tragic crimes. I've also had the opportunity and the responsibility of prosecuting police officers for sexual assault, domestic violence, and child abuse in my tenure with this office. My office's primary concerns with JPR 5 is that it fails to carve out an exception when police officers are victims of crime. What we know is that for every 1,000 sexual assault crimes committed in this country, only 230 are reported to the police. The number one reason is fear of retaliation for reporting his or her sexual assault. When an assailant is another police officer or perhaps a commanding officer or even a beloved member of the fraternal order, that fear is exacerbated. We do not want to criminalize a victim's choice not to report. We do not want to create an opportunity where this legislation could be used as a chilling effect to have a victim not report when they decide later that they are ready to report their sexual assault or any other type of crime. This legislation would subject those victims to possible prosecution. And while I use sexual assault as an example because we know nationally it is the most underreported crime, the same would be true for any crime in which a police officer is a victim. Victims should not be subject to criminal penalties for what is sometimes self-preservation. And with that, I would be happy to answer any questions.
Right on time. Thank you very much for your testimony. Thanks for hanging in there with us. Do we have Erica Hamlet? Ms. Hamlet?
Good afternoon. Thank you for having me. Almost 3 years ago now, almost to the day, November 3:45 in the afternoon in Howard County, a plane standing in his own community had a conversation with him, never identifying himself. When my son refused the interaction, the officer pulled his handgun on my son. Again, he never identified himself to my child. He was a grown man, plain clothes, out of his jurisdiction when he approached my child. It has been over 3 years, and I have been in the fight to hold this officer accountable to any extent. The process has been long, tedious, and unfair. My question is, what kind of accountability do we require for officers to have? Why is it that victims have to fight so hard while officers seem to get special treatment, preferential treatment, lawyers, follow the union laws, and victims are just victims again and again? When I followed the rules, went to the police station to file a report against the officer, my son and I were laughed at and told, at least he didn't die. We heard about your story. Come back on Monday. My son could have easily been a Mike Brown, a Trayvon Martin, And I don't understand how families grieve and fight for justice at the same time. And it makes absolutely no sense that we are begging for police officers to be held accountable to uphold the same laws that they are supposed to protect and serve. They are public servants, and all we are requiring is that due process is followed so that we as victims don't feel like these things fall on deaf ears. Thank you for your time.
Thank you, Ms. Hamlin, for sharing your story, and thank you for hanging in there again with us tonight, or this afternoon, rather. We'll go with,
Thank you.
Thank you. We'll go next with Ms. Pope, Jennifer Pope, and then we'll go to Minnie Pope right after that, and then followed by Ms. Hood. So Jennifer, Ms. Pope.
Hello and good afternoon, Mr. Chairman and members of the committee. First of all, I would like to commend everyone on this committee for even having this committee as needed as it is in this day and time. So first of all, saying thank you. In regards to police accountability, as a clinical social worker and therapist, I see clients on a day-to-day basis that suffer the traumas of being a constituent in Baltimore City and dealing with the police department. One of the things that I think that could definitely improve police accountability is showing that children and other other residents of the city that police can be accountable as well, that no one is above the law. We've seen far too many times where police officers have made bad decisions that has resulted in deaths of citizens in our city, and no one was held accountable. Also, as public servants, you have to know the public that you serve. There has to be more community engagement. I remember a time when I was young, we had a program called Officer Friendly, where officers would go around to schools, introduce themselves, and talk to young people and talk to kids. It's also very hard to police a community that you don't yourself live in. I know a lot of Baltimore City police officers don't even live in this jurisdiction. So it's kind of hard for you to relate to what's going on in the community or know what's going on in the community when you don't even reside here. Back in 2013, I had a very close family member that was a cousin that was murdered by Baltimore City police, plainclothes officers in Northeastern District, shot 7 times in a car moving with his teenage daughter in the passenger seat. This was supposed to be a routine traffic stop, but it ended up and resulted in the murder of Sean Dean. When we met with the state's attorney's office as a family, they sat and explained to us that policies were not followed, procedures were not followed, rules were broken. However, no one would be held accountable. That's completely unacceptable. When you have to police in a community where you are shown that you can never be held accountable for your own actions, you have a level of fear. And when acting out of fear, you go into survival mode, you go into fight or flight. So it's actually doing a disservice to their job by having such fearful constituents and citizens in the city. There has to be more engagement with the police department. We understand that they have a job, but it is a job. This is not something that they were required to do. This is not something that was mandated for them. They chose this position. They chose this job. They chose this career field. And if they are so fearful that they cannot follow the policies and procedures that are outlined by the law, the police department, and every other overseeing entity of police, then you shouldn't be on the department. You shouldn't be on the force, and you definitely shouldn't be in the streets of Baltimore. There are so many children that are so afraid of the police, they would never reach out to them in a time of need. Sitting on the Citizens Review Board, I've heard many stories of the people reaching out for help and actually turned up being victims from the police, the very people that they called for assistance, for help. So this has to be addressed if we want to see anything change. And I urge everyone on this committee to be the change maker, be the people who take that step that goes forth into our community and make a real change and show people that, yes, you have to be held accountable too as a police officer. You have to be accountable just like as the citizens are held accountable. I thank you for convening with this committee, And I'm praying that there's a real change, a real actual sustainable change that comes from you guys. Thank you.
Thank you, Ms. Pope, and thanks for hanging in there with us. I think we have Mitty Pope. I see your iPhone there. You're up next. Mitty Pope. All right, while Mitty is figuring it out, we'll go with Ms. Hood, Kristen Hood.
Hello, and thank you for giving me a chance to speak. I believe that it is imperative that we get back to community policing. In today's society, more than ever, the police need to communicate to the youth and into communities of color that they are here to protect and to serve. There's a significant fear of the police in the communities of color. We don't feel safe or protected. We have been resorted to kind of creating our own forms of law enforcement, which has created chaos in our communities. We feel as though sometimes that the police do not hear our cries for help, that there's no compassion for those of us who suffer with mental illness, those of us who suffer in just very high crime areas, and just often assume that we are the problem. I am here on behalf of my father, Alexander Pope Jr. He was a victim of poor policing, in my opinion. My father was detained in the middle of the heat after receiving chemo treatments at the University of Maryland. And again, in my opinion, due to poor police training and a lack of police accountability, my father, who was licensed to carry, was approached by 2 officers, including one in training. He was approached not only because of his firearm, but because he was a 200+ 6-foot tall Black man wearing a hospital mask. Him being armed with a firearm definitely warranted the police to approach him. However, what happened after that, in my opinion, was excessive. He was detained and asked to sit on the side of the road, not even taking into consideration that because this was before COVID, so no one was walking around wearing facial hospital masks. The University of Maryland has a very large cancer center and treatment center. So if police were aware of what was going on in that community, they would know that they see patients all the time with facial masks on after receiving treatments. He was asked again to sit on the sidewalk in the heat as he began to be searched to make sure that there was no other firearms on him. He was also sat there for quite an extensive amount of time as the police verified whether his license was official. Once they were aware that he was in fact licensed to carry not only here in Maryland, but in other states, they continued to allow him to sit there, even after he explained to them, I can't be in the heat. It was right at Lexington Market. He could have gone anywhere else or even been asked to sit in the police vehicle. But yet again, it was in the middle of the summer, 90-degree+ weather, that he sat there waiting as the officers just pretty much took their time after knowing what his health condition was. My issue is that oftentimes people of color, especially our Black men, are instantly viewed as a threat. I don't agree or don't believe that if he was a person who was not of color, that he would have been able to receive that same treatment. I think a benefit of doubt would have been given to him as they went and verified if what he said was indeed true. But again, that community policing and knowing the areas that you are in, knowing the kind of traffic and the kind of people who are there, that I completely understand having a firearm, and I completely understand having a mask on in another neighborhood would have warranted a panic and made the officers kind of think twice of what this person was doing. But even after the justification that even the officer who was in training explained to my father while sitting on the side of the road that he believed that things were a little excessive, that he just wanted to let him go, especially after they realized that, again, he was licensed. The fear that the community of color has for the police has continued to get worse, especially with what's happening in today's society and what we see in the media. I think it's very imperative that we, again, get to community policing and letting the youth, letting people of color know that the police are not here to harm us, to kill us, that it is indeed imperative that we have some type of trust in our police, that they are here to protect and to serve us. But again, that's something that we will not be able to do if we don't see it. And again, my father was just a victim of that incident. So thank you again for allowing me to speak. And I am hopeful that things will continue to get better if we continue to have platforms such as this.
Thank you, Ms. Hood. Thank you for your testimony, and thank you for sharing your stories. So next we'll go with Joe St. George, and then we'll go with Carrie Hansel, then Larry Greenberg, then David Kramer. So we'll go off with Joe St. George.
Good afternoon, and thank you, Chair here and the committee. Thank you, Jill Carter, and all of you who brought these wonderful bills together. I'm Joe St. George, a former political action chair for the NAACP, and currently leader of the Women of Color for Equal Justice. We have been working with Montgomery County with their use of force, and we were able to secure the language that we think that this state should adopt as state law, that particularly with regards to Bill number 1, the use of force, that use of force must be limited. We know that officers who are good officers are going to go above and beyond the limits. They're going to do everything that's necessary to preserve their life and preserve the lives of others. It's the officers who have other problems, biases, and other issues that need to have a higher standard to hold them accountable. And so we need a use of force bill that says, look, you can't use force unless it's necessary, it's proportional to effectuate the arrest, there's probable cause, there is seriousness you have to look at the seriousness of the underlying offense, and you have to exhaust all the alternatives before using force and look at the totality of the circumstances, but it must be law. And the reason why it must be law and not just a policy is because policies are often broken, and currently all the departments across the state have policies, but we clearly can see from the testimonies of all the people who've been impacted by excessive force in their families, that policies don't change behavior. Law does. And so I want to bring out a point with regards to a case that happened just recently in 2018. A police officer in Huntsville, Alabama, Officer Darby, went to support 2 other officers who were dealing with a potential suicide. And the 2 officers were in with the individual who had a gun to their head, was saying that they were going to kill themselves. Officer Darby was outside the building, ran in, and then ended up shooting the person who was clearly having a mental breakdown. The 2 other officers had the situation under control, was not afraid of their life. But what did Officer Darby say in the recent case against him just several weeks ago? I feared for their lives. I was concerned that they didn't have everything under control. He said all the perfect language that most of the case law, particularly Graham, says that an officer can say to justify the use of force. The Graham Supreme Court decision has laid a foundation that is so low that officers will only conform their behavior to what is the lowest standard in this country. And I, coming from Los Angeles, California, and was alive in there when the Rodney King beating happened, we are still living under the vestiges of that Supreme Court decision that has set a standard so low that officers know exactly what to say, how to say it to justify whatever behavior or whatever use of force that they use. And we, as a legislator, you as a legislator have the power to set the standard high, not to harm the officers who are really doing policing, but for those who have other agendas or want to use force in a very inappropriate way. Finally, we need to understand that over 60 or 70% of policing in this state and around the country, let's say, is not in stopping crime. Most of the interactions between police officers are for low-level infractions, and these instances of force are often used in situations where force is not even necessary. So that's why we must codify in law very strict language that tells officers what you can't do, because they know what they can do. And we need a bill that says, look, officers, you can't do these things. And those officers who are true to the badge, true to supporting their communities, they're going to do above and beyond what any bill could ever tell them. So we need to hold those accountable with a full-fledged bill that outlines what they can't do. And then the other 6 bills, I support them all. Thank you very much for your work. Have a good evening.
Thank you very much, and thanks for hanging in there with us. All right, so Carrie, you're up next. Thank you.
Thank you, Senator. Thank you, Senator. I appreciate the opportunity to be here today. My name is Kerry Hansel. I've been a civil rights lawyer in the state of Maryland for 20 years. It's been my honor to represent victims of civil rights violations during that entire time. And I'm here to strongly offer my support for your entire package and to focus a few comments first on JPR 1. It is critically important that we adopt a standard for the use of force in Maryland and that it involve minimizing the amount of force to the lowest degree absolutely necessary that is used by police against citizens. There is an absolute epidemic of police violence in Maryland. Let me give you some statistics. Reported by the FOP out of Baltimore County between 2010 and 2019 were 2,934 uses of force. That comes out to almost 1 use of force a day for 9 straight years. Out of Prince George's County, in the 4 years between 2016 and 2019, there were 6,805 uses of force. That is 5 uses of force by police officers against members of the public every single day for 4 straight years in Prince George's County. The Department of Justice tells us that these particular jurisdictions and jurisdictions across the country grossly underreport police misconduct. So when DOJ looks at these issues, they actually perform citizen surveys that haven't been done in Maryland. So these numbers are likely woefully underreported in Maryland. I will also tell the committee that with respect to internal affairs investigative records, it is critically important that they may be made available to the public. When an officer charges an individual with a crime, that information is public. Likewise, when an individual complains against an officer, that information should be made public. And if there's a concern on the part of the officer, then the outcome can be made public as well. Finally, with respect to the internal affairs point, the departments routinely in Maryland don't just hide under current law the complaint, but everything associated with the internal affairs file. So for instance, we can't get video, we can't get other evidence because it is taken from a video camera, from a dash cam, from a body cam, placed in the internal affairs file, and then we're told we can't get it because it's part of the IA file. So we're not only talking about allegations, but also hard facts, hard evidence that we as civil rights lawyers need. One more point, if I may, Senator Smith. I am the lawyer representing the family that was the subject of a no-knock warrant that somebody mentioned earlier when they said in their jurisdiction, they've only had 1 death. And I'll tell you, until you have looked in the eyes of that family and looked at a grieving woman who is left pregnant, who watched the father of her child die in front of her with multiple shots being fired by police after they threw a grenade into their bedroom. Until someone's looked in that woman's eyes, I'm going to respectfully suggest that 1 death is far too many based on no-knock warrants. So I'm here to strongly support all of this committee's work, and I'm committed to do so going forward. Thank you very much for your time.
Thank you very much for your testimony, and thank you for your work outside of your testimony here. It's impressive. So thank you for that.
Of course.
All right. So next we'll turn over to Mr. Greenberg, Larry, and then we'll go to Dave Kramer, and then we'll come back to Amity. We'll come back to you. So Mr. Greenberg.
On behalf of the Maryland Association of Justice, thank you, Chairman Smith, and the committee for any changes and actions that may come forth that will hopefully shine a bright ray of light across the stormy landscape and bring some needed and long-standing reform to police misconduct issues. Senators Carter and Sidnor, you both mentioned transparency throughout the hearings. while MAJ takes no formal position to JPR 2, I will tell you personally, because I do civil law and criminal law, the compilation and disclosure of data regarding police credibility or misconduct greatly tracks and allows others to uncover misconduct that shouldn't be tolerated in society, much less from the brave men and women who are there to protect and serve. Many today in this committee testified it wouldn't be fair for unsubstantiated claims to be made public. I will tell you that is what occurs every day to anyone charged with a crime. Whether a police officer or a citizen goes to a commissioner or swears out charges, guess what? The civil and criminal justice system are there to vindicate if vindication is necessary. They are allowed to defend themselves. Senator West, I too am from Baltimore County. I too appreciate the hard work that good members of our police force perform on a daily basis. But sadly, in my role as an attorney, I see firsthand that this system is broken. I saw personally with my own eyes a Baltimore County police officer who forgot body cam was on twice, tried to solicit other officers to be complicit in an attempt to create evidence for a traffic stop. When she realized the camera was on, shut them off quickly. Thankfully, the alleged perpetrator hired an attorney who got the body cam video, and we saw the dishonest acts. And instead of going to the media, instead of filing a lawsuit, the lawyer communicated with the very same state's attorney who was on today and the police chief to better the system. And ladies and gentlemen, I can tell you firsthand that as I sit here today, nothing was ever done. Nothing. Nothing was substantiated. Absolutely, there is no way for prosecutors, defense attorneys, or the public to see that this officer committed perjury and misconduct on the force. Senator Reddy mentioned system failures. I've seen firsthand those. You will hear tomorrow that in Prince George's County, I have a case going now where, as an officer of the force who didn't realize he was being recorded, assaulted my client, and you're going to hear from the client tomorrow, assaulted him, threw him to the ground, beat him, arrested him, and then lied under oath. IAD has sat for months and not required the officer to fill out a report or to give his statement. Prince George's County Police Department, the state's attorney's office that I've been in touch with, they have done nothing. Lastly, JPR 4. Mr. Hansel addressed it. Mr. Winkleman is about to address it. But I can tell you tomorrow you're going to hear from Makia Smith, and she's going to tell you firsthand that citizens feel that they need to react. It creates a dangerous situation. When other officers don't react, it encourages the public do-gooders to try to help those in need. And what happened in her case, she saw a police officer, she was driving and stopped in traffic, kneeling on a young boy's head, kneeling. And she got out of her car because she couldn't move. And she said, she was about to say, please stop. And she held her phone up to record. And as she recorded, an officer ran at her like a charging bull, grabbed her by her hair and beat her, destroyed her phone. And we had to go to court and to the Fourth Circuit to finally win. This is not how our system should work. Senator or Chairman and Senators, I thank you very much. And if you ever need anything, please contact us. We'd be glad to give you thousands, sadly, of victims of police misconduct.
Well, thank you for your testimony. I suspect a number of our members will be in touch relatively shortly. So
thank you, Senator.
Thank you. Okay, so next we'll move on to, we're on the home stretch. Ms. Conway, we'll move on to you, and then we'll move on to Mike Winkleman, Mr. Winkleman. So
great. Thank you. Thank you very much, Senator and Senator Smith. Chairman Smith, thank you for holding this hearing. I'm hearing an enormous amount of pain and fear, and I'm really glad that this is part of the process of the reckoning. Greta Willis' story left me with goosebumps, and I'm glad to see the League of Women Voters was here. The amount of energy is... Anyway, thank you for the hearing. I'm Diana Conway, president of the Montgomery County Women's Democratic Club, one of the largest, most active Democratic clubs in our county, with over 600 politically active women and men, including many elected officials. Our work at the county level has focused on ending police excessive use of force. We don't believe JPR 1 will deter excessive use of force because it lets police culpability rest on agency policies and training, and JPR 3 only restricts no-knock warrants. The legal standard of reasonableness in JPR 1 is a loophole that permits the police use of deadly force with some impunity. Specifically, elements of the reasonableness standard are viewed from the perspective of an objectively reasonable law enforcement officer, a standard derived from the Supreme Court's 1989 Graham v. Connor, which legal scholars point out moves the adjudication of constitutionally actionable harm at the hands of police from a rights-based systemic evaluation of excessive use of force, as might be applied under the 14th Amendment analysis, and examines it only from the specific incident in isolation from the systemic racist policing that may underlie the excessive use of force in the first place. This standard pits the victim against the officer and then views events from the officer's perspective only, without considering the officer's or the victim's race, although these disproportionately drive outcomes. And it doesn't require review of the officer's past use of force or pattern of racial bias or nature of the offense. We believe it is never reasonable for an officer to kill anyone over a counterfeit $20 bill, single cigarette sales, or walking in the middle of a street. We support JPR's rebuttable presumption that use of force is not reasonable if the officer failed to take every action to limit the likelihood of physical or deadly force. But the presumption can be rebutted if de-escalation is impracticable or if inconsistent with officer training or agency policy, which excuses officers from criminal culpability for physically injuring a civilian and lets agency policy and training determine if an officer acted reasonably, giving agencies too much ability to exculpate their own. We might support JPR 1 if other bills filled key gaps like banning chokeholds, strangleholds, and shooting at moving vehicles, and mandated things like de-escalation training. But JPR 3 only bans no-knock warrants, leaving training and policies for any other use of lethal force squarely within the agencies, a potential obstacle to holding officers accountable. I didn't realize we could address all the bills. We were trying to follow the instructions we were given. WDC has a lot of opinions, and I look forward to submitting subsequent testimony. Thank you.
Thank you, Ms. Conway, and thank you for all the work you're doing in the county throughout the state. And thank you for that very thorough and useful testimony. I think we're going to be in close touch as we move forward. So input's greatly appreciated. So for actually, before we go to Mr. Winkleman, I want to get Amity back in the queue. So take it away.
Hi, can you hear me?
You can, yes.
Okay. Thank you, Chairman Smith and members of this committee. I am Amity Pope, a doctoral candidate, president of Prince George's, and co-founder of PG Changemakers. Police officers are using militarized tactics, like in the instance where I witnessed 2 SWAT trucks with over 20 armed, geared officers locked and loaded to take down a neighborhood-known small elderly woman with mental illness for waving a bat on her porch simply because construction was waking her up at 5 a.m. And these are the officers that are policing our communities and schools, like Leonard Shan in broad daylight. By use of poor judgment and group dynamics, these officers were let off for not using appropriate de-escalation tactics. And in the case of Mr. DeMonte Ward Blake, who is now paralyzed from being body slammed on his neck while handcuffed during a routine traffic stop, with a 6-year-old to bear witness. As I understand the use of force bill as written, this bill would actually give police more rights than what the current law provides. The people don't want the standard of reasonableness to be likened to an objectively reasonable officer peer, because this standard right now allows for Maryland police to simply murder people. This is why we're requesting that community members be involved in crafting guidance on how police departments engage with people of varying cognitive and medical capacities, because reasonable standards equate to online videos of lynchings at the hands of officers claiming they feared for their lives with weaponless subjects. As written, this bill may be mistakenly given police broad discretion that criminal or racist police actually want the courts to afford them when they kill, maim, and falsely testify against Black, Latino, and poor people. not to mention the unsupervised SROs roaming the hallways of schools. We all know Maryland officers are now being found guilty of planting evidence on innocent people, raping undocumented people, and being indicted on brandishing guns at youth. Are we waiting for a child to get seriously maimed or shot dead by police before we make serious changes? Clear definitions of deadly force, less lethal force, necessary tactics and techniques, and totality of circumstances are all needed in a bill from the reasonableness of a human being. I'm Amity Pope, and on behalf of the many voices I represent when I speak, this bill doesn't address the priorities of our coalition, and therefore we oppose it as written. Thank you.
Thank you, Ms. Pope, and I'm sure we'll be in touch. So thank you for being patient with us today. Now we'll switch over to Mr. Winkleman.
Good afternoon, Mr. Chairman, and thank you for this opportunity. I am a civil rights lawyer in Prince George's County. I understand we're here today to discuss concepts more than actual legislation. And with that being said, I fully support the concepts that accountability and transparency are the key to real reform. Transparency in the context of police misconduct means greater disclosure of instances of police misconduct. Present law, particularly in civil litigation, discourages transparency and in fact promotes hiding prior bad acts by police officers. Every request we make for full disclosure of prior complaints of misconduct against defendant police officers is met with time-consuming and expensive fights with varying degrees of success. Accountability means there needs to be a remedy for people harmed by police misconduct. The law, as it presently exists, weighs so heavily in favor of police and local governments that I only take about 1 out of every 60 or 70 potential police misconduct cases I review. In the vast majority of cases I review, I feel confident that there was misconduct, but the law is too restrictive to provide remedy, and therefore there is no accountability. Mr. Chairman, you also indicated at the beginning of today, the issue of racial injustice is central to these conversations. I could not agree more. I am obviously white, but in over 20 years of doing civil rights work in Maryland and the District of Columbia, I have represented fewer than 5 white victims of police misconduct. The victims of police misconduct are overwhelmingly of a skin color different than mine, and this cannot be disregarded as part of the broader conversation. Moving directly to the proposed legislation, I fully support JPR 4 and the duty to intervene. If I may give one example of why this legislative ideal is so important. Some years ago, I represented the mother of a young man who was strangled to death by a police officer as 5 other officers watched and 3 civilians witnessed. I say strangled to death not because those are my words, but because those were the words used by the medical examiner who conducted the autopsy. A civil lawsuit was filed, and one of the primary defenses of the 5 officers who did not physically strangle the young man was that they did not have a duty to stop the strangling, and since they did not actually strangle the deceased, they should be dismissed from the case. There were also statements made through deposition that several officers were afraid to act because there was a superior officer on scene. This is unacceptable and needs to change. We need to change the discussion from officers being afraid to act against other officers to a discussion where officers are afraid not to act when they know wrongdoing is being done. Mr. Chairman, with your permission, the next 2 speakers are actually in the room with me. And so if I may simply turn the monitor to them and let them speak.
Thank you very much. Are we gonna?
My name is Marilyn Clark, and I'm here today to ask for your help in stopping police brutality. I grew up in Washington, D.C., and I have lived in Prince George's County for over 25 years. I am a co-educator in the Prince George's County public school system for 19 years. I am a mother, and I am a victim of police brutality, the worst type of victim. I am a mother of an unarmed Black man who was killed by a Prince George's County police officer. Brandon, my son, was making a delivery for Marlowe's Furniture in January of 2007 when he was shot and killed by a police officer. The officer who killed him had a significant history of complaints having been filed against him, documented mental health issues, and prior civil verdict against him for police brutality. Yet he was still on the force, fully equipped with a badge and a gun and police authority when he shot and killed my son for delivering furniture. I am not a lawyer. I do not understand the laws that are being talked about today, but I am a mother, and I can tell you if any new law can help save another mother from the nightmare that I have woken up to for the last 13 years, will be the best law ever passed. Thank you.
My name is Nathaniel Saunders. Brandon Clark was my brother. I'm here asking for your help to end police brutality. I was 17 years old, my brother was killed. Losing a brother was hard. Seeing my mother go through this every day for the last 13 years has been harder. Since she is the true victim of police brutality, her mother misses her son every day. I'm currently in law enforcement and employed by a municipal police department. I love doing what I'm doing. I always wanted to be a police officer since elementary school. I started in youth mentoring groups with Civil Air Patrol and also junior RTC in high school. And this made a tremendous impact in my life and along with my family life. I always wanted to be a good cop, and I saw the positive changes many people make in the community and also everywhere in life. And then my brother was shot by a police officer. We was treated like criminals in the hospital. My brother was handcuffed to the bed rail, being watched or police guard every day. We was denied access to see my brother for the week. But if it took 24 hours for the hospital even to call us, let us know that our brother was in the hospital. The system favors the officer over the victim during the time in the hospital. The death of my brother did not stop my desire to be a police officer. It pushed me even further to be a police officer. I wanted to show police officers could make a difference. I wanted to speak with a clear mind to the community. I wanted to show people a badge of gun did not make me better than anybody else. During my tenure as my role in the police department, I've done different drug recognition for high schools. I work with children age 13 to 18 with the Police Explorers program. I help mentor kids understanding the police officers are good people. I do not talk about death of my brother to my community groups or my students. In fact, I don't talk much about it at all. But I want to tell you today that my brother died while he was shot by a police officer. Anything that you could do to stop this from happening will be greatly appreciated. Thank you.
Thank you, Senator.
Thank you, Mr. Winkleman, and for Ms. Clark and Mr. Sanders. Thank you for talking about your son and your brother, and thank you for your activism. And obviously, you're honoring your son Brandon's memory by being here today. And so, we're going to work in earnest and do our level best. So, thank you for your time, and thank you for hanging in there with us today.
Thank you
for your testimony. We will now go down to Zain Shirazi, and then Ms. O'Neill.
Thank you, Chairman Smith. My name is Zain Shirazi. I'm a public defender who has been serving in Charles County for the last 5 years. And I'm a witness to the many police abuses that have occurred and continue to occur in Charles County. Yes, even in our medium-sized jurisdiction with a leader among Maryland law enforcement, police abuse is widespread, undisclosed, and unaddressed. Sadly, we have plenty of examples in Charles County of police use of lethal force that has gone unaddressed. Police use of lethal force is a major pressing issue that demands your attention precisely because it carries life or death consequences. But with my time here, I want to focus on police use of non-lethal force, because police use of non-lethal force is far more prevalent, also generating distrust of police and also traumatizing our communities, especially our Black communities. Just this year in Charles County, I myself represented a Black girl who was pepper sprayed for defending herself from the attacks of another girl and then forced to sit with the pepper spray still in her eyes and hair without getting it washed out. The internal use of force investigation said there was no dashcam footage to review. There definitely was dashcam footage. On another incident, an officer tackled a Black woman on a traffic charge because she was upset, not violent, just upset that her car was being towed. In another case, an officer slammed his arm into a Black man's head while the man was slumped and handcuffed in the back of the officer's vehicle. Police use of force is tearing our communities apart. Any police force traumatizes. Our Black communities far and away receive the brunt of police use of force. That creates racial trauma and it creates distrust. To combat this, we need many things, including a statewide use of force policy. And we need this use of force policy to look not just at the back end after the use of force has already occurred, but also at the front end before any force is used. We need a statewide use of force policy that prioritizes and requires officers to use de-escalation techniques whenever feasible, thereby also requiring agencies to focus on de-escalation training. We need a use of force policy that directs officers only to use force that is reasonable, necessary, and as a last resort, that prohibits officers from using force in certain situations, like to resolve a situation more quickly, and that requires officers to promptly provide medical aid. The current proposed reforms are a start for what we can do after the force has already been used, but we need a statewide policy that directs officers on how they should use force before the use of force occurs. And if we hope to heal and prevent further tragedies, Maryland's use of force laws must do far better than the bare constitutional minimum, which we have already seen is simply not enough. Thank you for the opportunity.
And thank you very much, and thanks for hanging in there with us today. Okay, we're going to actually go over to Miss Mariah O'Neill, and then Mr. Kramer. You're gonna round us out. So, Miss O'Neill, the floor is yours.
Yeah. Peace and blessings to you all. Thank you for listening to my story. I sit here today as a traumatized Black mother whose children's father was killed by the police on September 28th of 2019. On that day, I had to look my children in the eyes and let them know that their father would no longer be here. My children can go on the internet and see footage of their father being killed by the police. I sit here today with a heavy heart and a heavy mind at the fact that we are discussing whether or not a group of people who are paid and trained to protect and serve should be held accountable for their negligence and murders. The same laws that they are enforcing, they are immune to. If a doctor, lawyer, nurse, you or me unjustly kill someone on the job, we will be held accountable. Yet a job where you were taught to respond to crime is immune to the very crimes that they make civilians uphold. How many more hashtags do we need to fill the graveyards in our hearts and minds? How many more Black Lives Matter paintings do we need on the street before they wash away our loved ones' blood? Not passing this bill allows them to use their badge as a shield against police accountability. The bill should have been passed yesterday. Those deaths were not new. This has been going on for years. A traffic stop should not lead to your heart stopping. Alleged crime should not lead to a death sentence before due process. We are tired of symbolic victories. Hold the police accountable for their negligence. Police are not judge, juror, lawyer, or executor. If they're a good cops, they should be embarrassed by the actions of their co-workers. Passing this bill will stop unjust death of innocent lives and the God-given right to defend yourself and live peacefully. There should be no more Jamal Taylors or Tyrone West. America won't be great until you hold the police accountable for their actions. Thank you for having me.
Thank you, Ms. O'Neill. Again, thank you for hanging in there with us. So thank you for your testimony. Okay, Mr. Kramer, the floor is yours.
Thank you, Chairman Smith, and thank you for the committee members who have hung in all this time, especially listening to these stories, which are so moving. My name is David Kramer, and I'm a leader with Baltimore Surge, and I represent Surge on a coalition called Campaign for Justice, Safety, and Jobs. It's a coalition of over 30 organizations in Baltimore City that coalesced at the time of Freddie Gray in order to address police reform. We've taken a position on a number of pieces of legislation, especially on JPR number 1, the use of force. And while I understand that language for this bill still has to be sorted out, we just want to emphasize that it needs to be a higher standard. And there are examples of this, as had been mentioned throughout the hearing today. One I'm familiar with is in my own city of Baltimore with the Baltimore City Police Department. Its policy of use of force has quite a high standard. And I think it's important that this standard be applicable around the entire state so that it's consistent. SURGE is an organization that's part of this coalition because our role is to organize other white people to support racial justice issues, especially those issues that are defined by what we refer to as our accountability partners, who are organizations that are controlled and led by people of color. This is an important piece of legislation that needs to be passed. However, I need to comment finally on a legislation that has not been recommended among all those in 3 days of hearings, and that is local control of the Baltimore City Police Department. We also feel that this is very important to keep our own police department accountable. We're the only jurisdiction in the state that is not controlled by our own jurisdiction. And while this happened during the Civil War, it's about time that it is returned to our own control by our own elected representatives. And I'll end with that, and thank you for the opportunity.
All right, thank you, Mr. Kramer. With that, we have one last person. Darlene Kane. Ms. Kane, you are the last one on the docket for today, so the floor is yours. Ms. Kane, whenever you are ready.
It does not appear that Ms. Kane has audio.
Got it. Well, we can make some space for her tomorrow if she has the time, and then we will also review her written testimony if she has that available. But I think audio is connecting. Let's see. Okay, Ms. Kane, can you hear us? And can you speak?
Yes, now I can hear you. Can you see me?
Fantastic.
I've had a very difficult time. Good afternoon. Thank you so very much for taking this time to hear our voices today. We really appreciate you. I'm Darlene Kane, the mother of Dale Graham. I'm the president and founder of Mothers on the Move. I'm also a member of CJSJ, Moms Demand Action, and Baltimore Trauma and Grief member as well, team. I come here today because this is very personal to me because I lost my son Dale to the Baltimore City Police. And I am asking you to be in support of repeal the Law Enforcement Officer Bill of Rights. I'm also asking you for police accountability. We need that. I support the ANTAR's law, and I support the reform the Public Information Act. Because when Dale died, I didn't have any information on the officer who took his life, and I never made it to trial either. And I don't want no other mother, father, family member to go through what I've been through and how I suffered for 12 years. It's now be 12 years next month, October the 28th. And even with the camera footage, there hasn't been a lot of liability for the police officers for their action, for misconduct, or even for taking the life of another person. And it's unacceptable about all the excessive force that people here in Baltimore City receive from the police officers. So I am here asking for disciplinary action for police brutality, misconduct, and also, again, for people like me who never had a trial and our cases get justified and we don't have a judge or a jury to decide on the officer's action. It is so unfair to me that Dale was unable to see his two loving daughters grow up and attend college. Ayana is now 18, going to college. Janae is in City High School. And he never got a chance to see them grow up. Many siblings are without a parent due to the loved one killed by police. They're without a mother, a father, or two parents in the family. Families are now traumatized. They have fear of police officers, no trust because of the militarization of the officers coming in our community. We're outnumbered when all these cars are surrounding us. So I've come to you and I'm asking that you please support the bills that JLP Carter has also put in for us as well. And I do everything I can working in our community to make it a better place for a better Baltimore. And also to let people know that all the lives that were taken in Baltimore City by police officers mattered. Even the names that are not mentioned in the media on a daily basis, quote unquote, high profile. There's no such thing as high profile mothers, fathers, or cases. You know, we're all human beings. We are all a people who matter. We all matter. We matter while we're alive. We matter when we die. And Delegate Smith, I just want to thank you for everything that you have done and all the times I've been in Annapolis with Mom Demand Action and all the times I see that the hard work that you're doing as well. I do want to tell you personally and publicly that I do appreciate you. And so I want everyone to never forget those that lost their lives in Baltimore or in the state of Maryland. We still respect and condone the families and out of town, but we always want to condone Baltimore and the state of Maryland to not to forget our loved ones. We're so easy to remember those in other states. And that's very great because I marched in Minneapolis as well for George Floyd with other mothers who led that march. But we were there united in that fight. And I'm still united in this fight with all the mothers across this globe. And I also want to say that together, we can all work together to save lives. Together, as people, treating each other out of respect and dignity, we can. And because of all that we went through in the trauma, that's why I've taken up so many trauma classes, got so many certifications to learn how I can cope through this stress and how I can help other people from youth to adults that I train. And I just want to say thank you for this opportunity. Thank you for this time. And I truly appreciate you for everything that you're doing in Annapolis and beyond. And I hope that they get these laws passed so that we as citizens can be able to feel less stress in our own communities, be able to drive our cars in peace, walk up and down the street without fearing for our lives, just because we might have done something that might not have broke a law, but done something that may cause us to lose our life. Thank you.
Ms. Kane, thank you for your testimony. Thank you for hanging in there with us tonight. And thank you for obviously, again, sharing the story about your son. And it's a somber note to end on, but it highlights the importance of the work we have ahead. And I would just say that, again, as we close, thank you to Senator Carter and to Senator Sidnor. Senator Carter has obviously been leading on these issues for 2 decades. So
yes.
I think that I want to just call that out and highlight the work she's done. And we're going to do the best we can to support her efforts. So thank you for your time, and it means a lot to all of us. So thank you very much.
Thank you so much, Dan.
So with that ends the testimony for today. We're a little over because of, I wanted to provide an opportunity for the members to give opening statements. That obviously won't be the case tomorrow, so we'll be closer to the mark. And I apologize to every member for depriving you of another hour, but I'll make it up to you. So thank you all for hanging in here, and look forward to seeing you all tomorrow. So with that concludes.
Thank you. Thank you.
Thanks a lot. Thank you, Ms. Kane. Have a good night.
Thank you. How do we leave?